My lord, I am mentioning in connection with writ petition 671.
Monday is not the mentioning date. Monday is the mentioning date. Unless and until it is extremely urgent, which cannot wait till Monday.
One petitioner is a spinster. She is now acute financial crisis.
When you have filed the writ petition?
On former occasion, but it was not listed.
It is urgent matter. It cannot wait till Monday. Monday mentioning. Follow the procedure. If I allow your mentioning, then I have to allow others.
But the petitioner is now.
Please don't waste court's time in this fashion. Call the list.
Item number 1.
You have tried to mention this matter previously. I told you that you mention on Monday. Why you are breaking the rules of this court? When others are following?
On Monday, I was suffering from him.
Then Monday, next Monday you mention. Try to follow the decorum of the court. What is this? You are taking chance. Others are sitting, they are not mentioning, and I permit your mentioning. Yes.
Why? It was not possible for me.
It is for the release of the matter, for hearing matter. I mentioned.
You mentioned this matter.
I have given notice.
Ready for hearing.
Ready for hearing.
Matter has come up in the list under the heading to be mentioned on being mentioned by the learned advocate representing the petitioner for release of the matter. Stop. Next paragraph. Today, learned parties are today petitioner and you are appearing for
Respondent number 4 and 5.
State respondent.
and state.
State and
Today, petitioner and state respondents and respondent numbers 4 and 5 are represented by learned advocates. Next paragraph. As prayed for on behalf of the petitioner, hearing writ petition stands released. Stop.
Appearance দিয়ে যাবেন সবাই। Item number 2.
My lord, item number 2 on behalf of the Mr. Pathogus appearance of the petitioner, my lord. Appearing was short pass over.
Yes.
Pathogus on the appearance of the petitioner, my lord. He is coming, my lord.
Pass over, I do not grant.
Sorry, he is my lord, struck in the traffic jam on the road, my lord.
Till Monday. Not Monday, tomorrow. Tomorrow to be mentioned assigned. Not today.
Great.
Or dekhi. Today it is appearing under the heading to be mentioned.
To be mentioned.
You are appearing in this matter.
Lord, I don't know, my lord. My lord, just inform me, my lord. He is struck in the road, my lord. Kindly consider and pass over, my lord. Yes,
You are appearing for?
Respondent number 10, my lord.
Who are they?
Bengal Aerotropolis Projects Limited. My lord, the matter was previously listed before Honorable Justice Aniruddha Roy.
Industrial Development Corporation. What about the other respondents?
I am appearing on behalf of the respondent number 9. Body, Industrial Development Corporation. We have paid all as per my lord government petition to me, my lord. As per any case, my lord, we have already paid this government will pay the.
It's a matter relating to land acquisition.
They have challenged the acquisition process, entire acquisition process. Let us say the entire land acquisition.
When the land acquisition process was concluded by publishing award, who is appearing for the state?
My lord, on the last occasion, Mr. Supratim Dhar and Miss Tuli Sinha had appeared for the state on the last occasion.
Issue. Matter is accommodated in today's list under the heading to be mentioned. In terms of the order of the Honorable in terms of the order of the Honorable Chief Justice dated 19 March 2025, as the matter has been assigned to this court. Stop. At the time of call, accommodation has been prayed for on behalf of the petitioners. Stop. However, respondent, stop the however. Respondent number 10, 9 and 10. Respondent numbers 9 and 10 are represented by learned WBIDC. Yes, 10 is
For 10,
here.
my lord.
Respondent number 9 and 10 are represented by learned advocates. Next paragraph. Since acquisition proceeding is under challenge, representation on behalf of the state respondents is necessary. So, learned advocate for the petitioner is directed to serve notice upon non-appearing respondents or the learned advocates representing those respondents, enclosing copy of this order by April 17th, 2025, and file an affidavit of service on the next date. Affidavit service to the 17th April. Next paragraph, list the matter under the heading assigned motion on 29th April 2025.
Grateful, my lord.
Next.
Item number 3.
Lord, I have for the petitioner, my lord, your lordship earlier occasion heard the matter and directed DI to file a report.
Just a minute. Yes.
My lord,
Yes.
my lord, after your lordship's order, DI sent a letter referring a GO. That GO is not applicable to me, my lord.
Please, sir.
Where is it GO dated 15 March 2024?
Yes, ma'am. You only government employee you will apply this.
It is a case of government employee. How this is applicable?
ma'am.
And when the mother of the petitioner was in, the mother died previously, but it's a case of government employee. 15 March 2024, and what your DI was doing, this is a notification dated 15 March 2024, and when father died on 6 January 2023, and the school of the father died much before that. Father died, just a minute,
Second March.
2nd March 2021.
Yes.
And the school authority submitted the letter on 6 January 2023.
Yes, ma'am.
Requesting district inspector of school secondary division Purba Medinipur to sanction family pension. At that point of time, this memo was not there. It was the delay on the part of the district inspector of school, for which now the compliance of this memo dated 15 March 2024, which was issued much later, has to be considered for the delay caused by the DI. What your DI was doing after receiving this letter from the school authority relating to settlement of family pension case of the petitioner dated 16 January 2023, 6 January 2023, and now DI is submitting a report and taking a point that this memo is required to be considered. This memo is dated 15 March 2024.
Yes, ma'am.
How that is permissible? 15 March 2024 memo that is concerning government employees, and this memo was issued prior to that. The father of the petitioner died on 2nd March 2021. School forwarded it. DI has admitted on 6 January 2023, and from January 2023, what you are doing?
17th January.
2023.
Yes.
How this memo dated 15 March 2024, which has no retrospective effect, is applicable in this case?
But as I understand, my lord, from
Shall I direct the authority to stop the salary of your DI? He is playing with the fate of the family pensioner. Why your DI kept mum during this period after this order, this letter was sent on 6 January 2023, till this last memo was issued on 19 March 2025?
Perhaps, my lord, it is tied
Perhaps.
tied to, my lord, explain, my lord, at paragraph 2, my lord.
Yes, place paragraph 2.
My lord, as, my lord, the report.
Paragraph 2 of the report. Yes, I humbly submit. Yes, place it.
That the necessary document. Daughter's family pension or not.
Very well. Let us come to the this photostat copy of the letter is annexed here too. Where is that letter?
My lord, annexed,
No, this is the letter of the school authority dated 66 January 2023. Haldia High School HS.
yes, that is true, my lord.
Where is the memo of the DI?
I handed over.
Necessary documents as noted so and so for sanctioning the unmarried daughter's family pension were not annexed to the said forwarding letter. Show me that letter.
Were not annexed to the state forward.
Oh, you have received this letter
19 March.
19 March 2025 letter.
Yes, ma'am.
That is annexed to this to this report.
That and such deficit was informed,
Where from you are reading?
paragraph 2 last line, my lord. Paragraph 2 last line. And such deficits was informed to the school authority.
For sanctioning unmarried daughter's family pension were not annexed to the said forwarding letter, and such deficiency was informed to the school authority verbally, but the said necessary documents were not submitted. What are those documents?
My lord, my lord,
What are those documents? Tell me. I thought that these documents are disclosed before this court. What are those documents? DI has filed a report.
deficit report, my lord,
What are those documents? Show me that what are those documents. Don't make any vague submission.
no, I am not.
Where are those documents? And your DI is saying that it was intimated to the school verbally after receiving letter dated 6 January 2023. And your DI was sleeping from 2023 till this memo was issued on 19 March 2025 after the order passed on 19 March or on that same date order was passed on 19 March.
My lord, the last paragraph.
This is the letter of the school, first annexure. Now your DI has said that there are requirement of forwarding pension file with necessary documents. Those documents are not disclosed in the report. And now your DI is saying that GO number 15 March 2024 is required to be complied with. Why? This memo has no retrospective effect. Father died on 2nd March 2021. School authority sent the papers on 6 January 2023. So, and this memo was dated 15 March 2024. Show me that it has got a retrospective effect. And your DI is silent that what are the documents required?
My lord, the documents, my lord, if you lord see, my lord, from the.
Very well, I will direct the DI to really settle the family pension case within a period of 4 weeks from date. And if necessary, income certificate and legal aid certificate shall be produced before.
What are annexed here?
You have annexed.
Yes, ma'am. My lord, that.
So where are the annexure?
Page 24, my lord, legal year certificate.
My lord, in accordance with law.
Serial 6, unmarried daughter.
Serial number 6.
Yes, my lord. Page 24,
Married daughter,
CL 6.
married daughter, married daughter.
Masuma Khatun, unmarried daughter. And also disabled man.
And 25, my lord, if you lord.
Who will pay the interest from the pocket of the DI
My
or
lord,
delay caused in releasing family pension?
My lord, kindly see the income.
Yes, where is the income certificate?
Income certificate, my lord. 25. my lord.
This certificate by the Haldia municipality will not.
Under,
There is a block development officer or SQ has to sub-
under municipal corporation, my lord, municipality, my lord. This
No, my lord,
this
kindly
is
see
the
page
authority.
13, my lord.
Under municipality, my lord, BDO is not authority.
My lord, now kindly see page 13, my lord.
Department.
Income certificate, my lord, page.
Issue.
Also, my lord, this memo is only
In
applicable.
terms of the order dated 19 March 2025, report dated 25 March 2025 of the District Inspector of Schools AC Purbo Medinipur, dated being respondent number 4, dated being respondent number 4, is placed before this court and same is taken on record. Next paragraph. On perusal of the report, it appears that the respondent number 4 has admitted that Huldia High School within bracket HS close bracket Purbo Medinipur, where father of the petitioner worked as assistant teacher, forwarded the prayer of the petitioner for sanction of family pension being unmarried daughter of a deceased teacher on 6 January 2023, which is enclosed to this report. However, respondent number 4 has stated in the report
রিপোর্টের কপি দেবেন
হ্যাঁ, এটা আমাদের ক্ষেত্রে প্রযোজ্য না, এটা গভর্নমেন্ট এমপ্লয়ি দেখে।
in his report, stated in his report that in terms of geo number but this geo number is not telling
Your number is not applicable.
that. Just a minute, it is the geo which you have placed before this court is 202 if pension dated 15 March 2024, and in paragraph 2 of the report it is referred to that 96 ACB IM 1122008 2008 dated 13th April 2010.
No,
It's not telling.
that 202, my lord, is referred to as annexure page 2.
This is the relevant June 13th April 2010.
Yes, ma'am, that is annexed in my writ petition.
That is the relevant June.
Yes, ma'am, yes.
কি বলছিলাম? Geo in terms of geo number, na in terms of government order, in terms of the government order dated 13th April 2010. Requisite documents were not forwarded by the authority of Huldia High School within bracket HS or opore na herein আপনারা referred to as a said school করে দাও, করে close bracket করে কোট আনভার করে is for কি বললাম শেষে said school and which was verbally informed to the school authority. However, in the report, nothing is spelled out that what are those documents which are required for settling the family pension case of the petitioner. Stop. At the same time, a contradictory stand is taken. Or a contradictory at the same time, a different stand is also taken by the respondent number 4 as it emanates from memo dated 19 March 2025 issued by the respondent number 4 addressed to the headmaster of the said school, wherefrom it appears necessary papers are required to be submitted in terms of government order number 202F within bracket pen, P capital, PEN, bakigulo small, PEN close bracket, dated 15th March 2024. Stop. Next paragraph. On perusal of this memo dated 15 March 2024, in terms of memo dated 15 March 2024, or the government order which has been referred to in the memo dated 19 March 2025, issued by the respondent number 4, was is dated 15 March 2024. Whereas father of the petitioner died on 2nd March 2021. Therefore, the said government order dated 15 March 2024 has no manner of application in settling family pension case of the petitioner, since the said government memo dated 15 March 2024 does not have retrospective effect. Stop. In addition thereto, it also appears that this government memo dated 15 March 2024 is applicable in case of government is applicable to the government employees, whereas father of the petitioner was an assistant teacher of a government aided recognized school. Next paragraph. In consideration of the facts of the present case, it appears respondent number 4 has unnecessarily caused delay in sanctioning, in processing family pension case of the petition. Though after death of father of the petitioner on 6 January 2023, VD letter dated 6 January 2023, family pension case was sent by the said school authority to respondent number 4. Stop. On perusal of the writ petition, it further appears that legal year certificate dated 3rd November 2022 was issued by the appropriate authority, and income certificate dated 12 July 2024 issued by the chairman in council of Haldia municipality was issued and income certificate was also issued by the chairman in council Haldia municipality. Stop. Next paragraph. In view of aforesaid situation, And aforesaid situation, respondent number 4 is directed to settle the family pension case of the petitioner based on the income certificate and income certificate dated 12 July 2024 and legal age certificate dated 3rd November 2022 by 4 weeks from the date of communication of this order. Stop. Since father of the petitioner was in receipt of pension, the pension file must have been maintained by the office of the respondent number 4. And any relevant documents which are available and relevant relevant documents which are available on pension file can be considered by the respondent number 4 while settling the while releasing or while finalizing the family pension case of the petitioner. Stop. DI shall the respondent number 4 shall release family pension in favor of the petitioner if he is otherwise eligible as early as possible. No, that last sentence ta bolo.
Respondent number 4 shall release.
Now, the respondent number 4 shall pass an appropriate order for releasing family pension in favor of the petitioner if she is otherwise eligible by the aforesaid period of 4 weeks and the Director of Pension, Provident Fund and Group Insurance being respondent number 2 shall issue necessary pension payment order within 2 weeks thereafter. Stop. Family pension shall be released in favor of the petitioner at an early date, but not later than 8 weeks from the date of communication of this order. Writ petition stands disposed of. Urgent xerox certificate.
One thing under the law, page 13, the income certificate is not in accordance with page.
Yes, I have seen. Next matter. Your DI, you are sleeping and now coming with a government order which is not applicable.
2 copies I have handed over my lord. One report.
কি কপি দেখো তো আমাকে আগে দেখাও দেবে না দেখি হুইচ কপি রিপোর্ট
রিপোর্টের দুটো চলে গেছে একটা
রিপোর্ট একটা কপি নেক্সট ম্যাটার
My lord, I am for the school authority.
Lastly taken up on 18th of March, wherein time was prayed by the representative of the state. My lord, what happened in this case?
Yes.
The present petitioner is the assistant teacher of Kontai town, Rakhal Chandra Vidyapit since 7th of September 2007. After becoming a member of the managing committee.
You are appearing for?
I am for the school authority.
After
Well,
becoming.
earlier occasion, my lord, I was not here. On my behalf, someone taking time in another matter. But that day I had caught the heat. I was feeling unwell and left the court. That is why, my lord,
Yes.
today I am here, my lord.
After becoming a member of the managing committee, this petitioner came to know about the numerous illegalities committed by the headmaster of the school and vehemently objected to the same and submitted several complaints before the concerned respondent authorities. For the last 8 years, this headmaster has been arranging paid coaching classes for a section of sent-up students by forcefully compelling each of such student and their guardian to illegally pay fees of an amount of rupees 1,000 to the headmaster, and then the said fees have no connection with the amount of fees which.
So you have challenged 8 February 2025 notice.
Yes.
Where
my
is
lord.
that notice?
What happened, my lord? My lord, before that, my lord, kindly
Please show me the notice
Yes.
first. Page 84.
84 and 86. Now, my lord, headmaster is not allowing to attend the class. I am unable to attend the class.
So, according to you, that you are not attending you were not attending the school from 9 December 2024.
No, according to me, I was absent in only 2 dates. That is on 2nd of January. Sorry, 3rd and
December.
4th of January. Only 2
What
dates.
about what happened from 9 December
Yes,
2024?
I am regularly attending I am regularly coming to the school. They are not allowing to put my signature in the attendance register. And my lord, the headmaster is not allowing me to attend the class.
May I submit?
So
My
you
final
is
representation.
his application.
Sorry.
My final
It is
representation.
you regularly attended the school
Yes,
during
yes,
that period, but
regularly.
you could not join the
Yes.
could not put signature on the attendance register.
Yes. Page 73.
Have you brought it to the notice of the TI?
My lord, I have, yes, my lord, page 74.
The travel started from 9 December, as it appears from the this letter or this impugned notice dated 8 February 2025.
My lord,
And
trouble,
this representation is dated 7th February 2025.
my lord, trouble started much before. When I protested.
So why this representation in the month of February after 2 months?
No, my lord. My lord, on several occasions I have lodged complaint. Page 59 onwards. Page 59 onwards.
Show me your first complaint.
Yes, page 59. আচ্ছা তার আগেটা কত তাহলে? Page 43. Sorry, my lord, page 43. First complaint is in page 43 to 56. Page 43, first complaint.
No, after you were being prevented from putting signature on the attendance register on and from 9 December 2024, where is your first complaint to the DI?
তার আগে December তো page 50, my lord, I'm showing, my lord. Complaint page 55, page 55. You know, page 55 also, my lord, kindly see. When it
Show me your first complaint after you were prevented from putting signature on the attendance register.
Yes. Page number 59. 6 January. Yes. In the middle of page 59, specifically stated. In the middle of page 59. Shall I read, my lord?
No, just a minute.
এটা তোমরা লিখে দিচ্ছি কমিশনার প্রিন্সিপাল
But you have stated it when I was asked for a reason. You threatened me by saying that you will not let me sign the attendance register.
my lord.
The next 2 dates,
Yes, only
that
2
is
days I was
3rd
absent.
January and 4th January.
Yes, only 2 days I was
But
absent.
the headmaster is saying from 9 December you are not attending.
9th December I was absent and thereafter 2 dates.
So that is 3rd January and 4th
and
January.
bas.
But the notice, impugn notice says, as per resolution of the managing committee so and so, in connection with your absence on 9 December 2024 and your letter as you were absent in the school on 9 December Monday, that your application is. So you are only absent on 9 December. Thereafter you attended the
Yes,
school, put
absolutely.
signature.
Yes.
So now what is the problem?
Now problem is, if your lordship sees page 59, I came to join the school today with an application for granting my sick leave, but to take revenge, did not receive the leave application.
Page
at
29.
59.
59.
Yes. And sign the attendance register. I was forced to come back.
Now you are regularly attending the
regularly
school.
attending, regularly.
So you have challenged this
My
this
lord.
notice.
Yes.
It is not this court was under the impression that now you are not attending the school.
No.
That is not the fact.
My lord, they are
Now you are regularly attending.
Yes. Now they are not allowing me to put signature in the attendance register.
From which date?
From that date, my lord.
9 January.
6th January. From 6th January, page 59. From 6th January, they are showing me absent. Right? 6th January, আপনাকে absent দেখাচ্ছে তো 6th January থেকে তো এখন আপনি যাচ্ছেন স্কুলে না আমাদের অ্যাটেন্ডেন্স ওকে ঠিক আছে 6th 6 January.
So from 6 January you are not being permitted. Yes.
Yes. My lord, the writ petition now the my lord infructuous because vis-a-vis allegation before the board. The board has taken a decision direct the DI concern of the said district to form a committee, inquiry committee, and the notice was served upon the headmaster and the incumbent, the petitioner before your lordship. And yesterday, the hearing was concluded.
That is for preliminary inquiry.
No,
Prior to initiation of disciplinary proceedings.
everything, my lord, everything. Your lordship, I'm giving.
No, I am asking you that why at present your headmaster can prevent the petitioner from signing the attendance.
No. He is not coming. He is not coming.
Very well. I will
And
direct the police
yesterday-
authority to remain present in the school, and an assistant inspector of school, he will put signature on the attendance register
Yes.
or tomorrow,
Yes.
and a report is to be
But
published.
subject to correction, one thing.
Purbo
he has
Medinipur
given-
is very much known to us.
No. Yesterday, he has given
This
undertaking.
district has checkered history.
No. Kindly
It
see
is
the.
very much known to us.
Yes.
Why is there any suspension, Mr. Giri,
No.
or any
We have-
punishment order?
No.
Then how your headmaster can prevent him from
I am
signing
I
on
am
the
always,
attendance register?
kindly see the activities of the teacher. I am always accompanying.
So for that, all on a sudden, from 6th January, he is to be prevented from signing on the attendance register
he willingly has not come to court. You lost direct the DI.
and has filed a writ petition. So he is not coming to the court. He is not coming to the school
Yes, certainly, my lord.
from
Kindly
6th
see the-
January.
Kindly see the
Very
note.
well. Well, so you have no objection if he comes to the school and puts signature on the
Yes,
attendance
yes,
register?
come to.
Yes.
I have no objection. He has given undertaking before the inquiry committee. Yes, I will go and sign tomorrow.
No.
Today is the holiday. Your lordship kindly.
Mr. Chattopadhyay, ask the DI to depute one assistant inspector of schools. He will be there in the from 10:30 in this at the school premises, and
Every day.
first day, not
Tomorrow.
every day, tomorrow.
Well,
Tomorrow, petitioner will come and put signature on the attendance register, and thereafter he will prepare a report to the DI, and DI shall submit a report based on the report which is to be furnished by the assistant inspector.
report here or board?
Yes.
Your lordship currently starts page 43, the representation made by the teacher. That ego problem of the teacher. Petitioner
Maybe, but for that he will not be permitted to join the school.
No, I am already inviting. I am already inviting.
AI school inspector went to the school, resolve the problem that will be reflected from the letter of the petitioner page 43. So every time,
At this stage, court is not required to enter into those issues.
certainly,
If any misconduct or any dereliction of
that
duty,
will be
or if anything which is not commensurating the status of a teacher, then an appropriate proceedings has to be issued with the proceedings has to be initiated with the assistance of or by the concerned authority of the board. Now the school this court is not required to enter into this aspect. Only thing is this: no suspension, no punishment order. Why a teacher will not be permitted to resume duty by putting signature on the attendance register? That I want that should be ensured, so that the petitioner can attend the school, put signature on that.
And when I
One subject to correction. One point.
I
One
want to
sentence.
attend
One
the classes also.
Yes,
All the your lordship just have been stated, my lord. All the problem yesterday, the inquiry was from and hearing was concluded, and my lord, that inquiry to come and assure that I will attend the school today. Today is the holiday, and thereafter he told that I will attend the school tomorrow, 11. And this is the your lordship, kindly go through it. Then your lordship pass the order. I am not objecting. Kindly go through the suppression of material fact.
No, no, no.
Yes,
I have-
certainly.
Question of suppressing
Yes,
the
yes.
material
Kindly
fact
see.
does not arise. My lord,
Then whole
পার্টে তো আমরা
problem will be
ঢুকিয়েই
solved,
নি।
my lord.
এই পার্টে তো আমরা এখনো ঢুকিয়েইনি। There were two
Then
allegations.
a report will submit before the board. The board will decide whether he will be suspended or. That is why this is the proceeding.
বলবো কার বলার স্কোপ আছে নাকি? তো নিশ্চয়ই বলবো, আমাদের কাছে ডকুমেন্ট আছে।
না না, কালকে যেটা হয়েছে সেটা বলতে হবে তো বাবু।
সেটা না, এই তো আন্ডারটেকিং কিছু। এই তো লেখা আছে।
All the notice, headmaster and also the
Not
assistant teacher.
They are also same thing reiterated from 6th of January 2025 to till date classes, he was not allowed to attend the class.
just a minute.
এই তো দেখেছেন আপনি, সমগ্র বিষয় ঊর্ধ্বতন কর্তৃপক্ষের নজরে আনা সত্ত্বেও আমি কোনো সুবিচার না পাওয়ায় আমার মাতৃসমা প্রিয় বিদ্যালয় সহ সন্তান সমূহ ছাত্রছাত্রীদের
ওই
থেকে
জন্য তো
বঞ্চিত
কালকে
হয়ে আছে।
হিয়ারিং হয়ে গেছে।
আরে হিয়ারিং কি হয়েছে? তো আমার এগেইনস্টে যে অ্যালিগেশন সেটা
All the document be kept on record.
Yes, inquiry was scheduled to be held on 9th of April.
Tomorrow.
So,
Yesterday.
yesterday, then what happened in that?
Then, my lord, the inquiry committee direct the writ petitioner to join. He assured, yes, I will join tomorrow. Today is the holiday, that you are tomorrow.
Well, I am fixing a matter after some time. Let me see what happens.
As your lordship, all the document be kept on record. I will not return. Your lordship can be kept on record.
Committee was formed
No, since an inquiry was held on 9th of
regarding
25,
which, my lord, fact,
and there, if he has assured that he would join,
my lord.
and in the you go and join from
Absolutely,
tomorrow.
my lord.
If you are prevented or if you find any difficulty, bring it to the notice of this court on the next date.
Grateful, my lord.
Let me adjourn the matter for some time in order to see the developments which may take place pursuant to the inquiry which was or the meeting which was held on 9th April 2024.
My lord, in the
And
meantime,
also, a
for
question
which
was,
reason,
upon the petitioner, you join and report the inquiry committee.
my lord,
Then we'll
my lord,
send the report
in
to
the
the board.
meantime,
No, has it been decided by your assistant inspector of school or deputy additional district inspector of school on 9th of April 2025 that an assurance has been given by the petitioner that he would join and the school authority will
Yes,
permit?
yes, certainly. He undertake.
my lord,
He undertake himself.
my lord,
And I will join today.
Do you have any instruction to that? No. You obtain an instruction and file a
my
report.
lord, I am always ready to attend the class. In the meantime, my lord, kindly direct them to supply on which basis, my lord, one inquiry committee was formed. That I did not
Affidavit
know.
of service, Mr. Chatterjee.
Yes, yes. Well, that those documents are to be supplied
Affidavit of
upon us.
service filed on behalf of the petitioner is taken on record stock. Next, in the writ petition, notice dated 8 February 2025, issued by the headmaster.
Well, probably on earlier date, my lord, I have
Town.
they deposited the affidavit of service because on that date also, my lord,
No.
they are
No.
they appeared on the
It is
earlier
not
date
recorded
also, my
and
lord.
there is no affidavit
Yes,
of
yes.
service.
আমি
আপনার তরফ থেকে কেউ টাইম চেয়েছিল তো?
না আমি appear হয়েছিলাম।
ও আপনার তরফ থেকে টাইম চেয়েছিল। ও আচ্ছা,
Not there.
সরি মাই লর্ড, I found.
কি বললাম?
ও আচ্ছা।
Issued by the headmaster of affidavit of service filed. Where is the affidavit of service?
মাই লর্ড, সার্ভিসটা কোথায় গেল?
Issued by the headmaster of Pontai Town RC Vidyapit within bracket HS Purbo Medinipur. Hereafter referred to as the said school. Stop. It is submitted by Mr. Chatterjee, learned senior advocate representing the petitioner, that that the petitioner is an approved assistant teacher of the said school who is being prevented illegally from signing the attendance register from 6 January 2025. 6 January 2025. Signing the attendance register from 6 January 2025. Stop. Stop. Petitioner prays for necessary stop. Petitioner prays for necessary direction in which would permit him to attend the school regularly and put signature on the attendance list, or by putting signature in the attendance list. Next paragraph, Mr. Somiran Giri, learned advocate representing state school authority, submits an inquiry was held on 9th April 2025 by the additional district inspector of schools,
Inquiry committee.
or under the aegis of additional district inspector of schools, where headmaster of the said school, your headmaster were present,
Yes.
where the headmaster of the said school and the petitioner remain present. Stop. It is submitted. It was submitted on behalf of the petitioner before the inquiry committee headed by additional district inspector of schools, that he would attend the school and put signature on and from 11th April 2025 regularly and an undertaking was furnished
Undertaking
by
by
the
the petitioner.
by the
Undertaking
petitioner
a
to that
copy
extent.
No, my lord, only my humble prayer. My lord, kindly see this document. No,
And an undertaking to get stop. It is also submitted by the learned advocate representing the headmaster that it was submitted before the inquiry committee on 9th April 2025 that the said school authority would permit him to attend the school regularly, allot classes and sign attendance register. Stop. Next paragraph. In view of such submission made on behalf of the school authority, on behalf of the headmaster of the said school, in reference to an inquiry which was held on 9th April 2025. At this stage, no further order is required to be passed. Next paragraph. Next, petitioner. Now, the said school authority is directed to no further order is required to be passed, except directing the said school authority to permit the petitioner to attend the school regularly and take classes, and also the school authority shall allow the petitioner to put signature on the attendance list. Stop. Next paragraph. List the matter under the heading motion on May 6th, 2025 in order to find out or in order to assess the developments which will take place in the meantime. Next paragraph. The district inspectors or additional district inspector of schools, AC Kontai, additional district inspector of schools, AC Kantai, has he been made party?
most probably we have made him party.
Yes. Respondent number 7.
Number 7.
AC Kantai being respondent of 7 is directed to file a report in the form of affidavit on the next date. Next paragraph. Learned advocate for the petitioner is directed to file affidavit of service on the next date.
Because the inquiry is conducted by the AI under the order of the court. Regarding the inquiry, I will not take activity.
But no document has been supplied upon us also.
We will submit a report that whether the petitioner is being permitted regularly. And what was the decision taken on 9th April 2025?
We have sent the notice or no notice, but everything has. My lord, one humble prayer.
Is under challenge.
I have submitted document that we kept a record.
One humble prayer, my lord. Affidavit of service misplaced. They have appeared, my lord. My lord, shall I, sir, give them notice and prepare once again, my lord? পরের দিনের জন্য নোটিশ করতে হবে। আরে ভাই মিসপ্লেস করতে ফাইলটা ইয়ে করব কি করে?
All the notice be kept on record, my lord.
ঠিক আছে, দেখছি কি করা যায়।
A memo dated 3rd of April 2025, along with other relevant documents. Now, memo dated 3rd April 25 issued by the inquiry officers and assistant inspector of schools within bracket AC, Kontai subdivision, Purbo Medinipur, along with other documents, along with copies of other documents, which are placed before this court are taken on record. Stop. You issue fresh notice and file affidavit service.
My lord, grateful, grateful, grateful.
Next,
Item number 5.
6th May.
Get close.
For the petitioner. Petitioner, the assistant teacher, and asked me to the Kechuria. Not choose. They are not. He has transferred. She has been transferred. General transfer, my lord, to the Bangalore. Then, my lord, representation was filed, providing some relevant documents for correction of the service book and other related. My lord, dear my lord, assistant director, I see the page 40. Page 40. Inspector of school also. Thereafter, further, my lord, representation has been given to the respondent. Sitting tight over the matter. As per the knowledge of the petitioner,
why fast recognition memo of the school is required while forwarding the papers?
the service book.
No, you have prayed for in your in the prayer A that the fast recognition memo of so and so school. Why it is required? You have taken transfer.
The authority of the Bagbajar said, my lord, it is required.
Why? Why? Tell me.
In spite of that, we have
Authority
given.
Who is
I am for the school authority, my lord. This writ petition is, my lord, frivolous writ petition, my lord. Required to be, my lord, dismissed with cost, my lord. My lord, we have, my lord, given entire document. Her contention is that till today, my lord, PF has not been transferred. This is the document, my lord, on 12th of October 2021, PF account has already been transferred to the school.
That has been done.
With a memo number.
When the
My lord,
representation
petitioner has been.
The representation has been filed. It is the duty of the respondent authority.
Why you are making the representation in spite of receiving all the documents? Only to making complaint before the different authorities.
Approved order may be passed.
Why? What for representation?
No, it has not been.
My lord,
Most probably.
not only that, my lord.
One person will not come before the lordship, my lord, unnecessarily. It is so, my lord, then it may be recorded, my lord. Then no.
It is a transfer within the same district or different district?
Different district.
Not 24 Pargana to Kolkata, my lord. Bagbajar. And page 40 also. Authority concern issue.
বলছি
It is done to authority concern.
আরে সব জানে
Unnecessary আছে।
পিছনে লাগার জন্য এগুলো মামলা
Unnecessary কেন আছে?
Not 24 Parganas to
কলকাতা
Kolkata, Bagbajar, Bagbajar.
now petitioner is working in which school?
Bagbajar.
Bagbajar school. What is the name of the school? Bagbajar High School.
Bagbajar High School. 29A, Bospada Lane, Kolkata থেকে। The respondent number 11. Respondent number 11.
আরে ওর অ্যাকাউন্টে জমা পড়ে যায়, এটা স্টেট করে, স্কুল করে না, ডিআই করেছে, সব জানে, অ্যাকাউন্টস আছে, ওকে জিজ্ঞেস করুন।
DI তো 6
একটা 50,000 টাকা কস্ট ইম্পোজ করে দিন তাহলে
এখন এই নদিন ওইদিন knowledge
দিন দেন
টাকা দেওয়া বলতে দেশের টাকা দেখো না আমাদের ঘরের টাকা চুপ করে
Additional District Institute of School Secondary Education Bosirat Subdivision has already issued a memo for transfer of rupees 4,35,981 to your present school. So why you are
not only that, my lord. Yes, sorry.
Why you have filed this writ petition?
No, my lord, kindly see my lord, page 40, my lord. Notice has been issued, my lord. District.
Page 40.
Yes, my lord.
On submission of department.
Service book transfer হয়ে গেছে এটা। Well, তার আগেই হয়ে গেছে। এটা ও কমপ্লেন করেছে বলে বলেছে। স্টেপ নাও।
আমাদের কাছে রাইটার পাচ্ছিল তাতে নেই তো ভাই নেই তো
কমপ্লেনটাকে ট্রান্সফার করছে।
So come to page 40 as you are relying upon. Last sentence, apart from first paragraph, apart from this, she did not submit other relevant documents till date, such as Provident Fund statement. Already it appears that Provident Fund account amount has already been transmitted. Provident Fund statement, last pay certificate, managing committee resolution regarding her joining, and release order, deduction of salary in connection to her service period of school, which may be required for future issues. It has not, these documents have not been furnished, not been forwarded. I will call for a report from the DI, but if I find that these documents were forwarded, then heavy cost is to be imposed upon the petitioner.
kindly allow me. If it is
I am asking you whether these documents have been forwarded or not to the present school of the petitioner.
সব পাঠিয়ে দিয়েছে।
as per the knowledge of the petitioner, my lord, after the same, if it is not within my knowledge, my lord, it is the school DI, assistant DI, it is suppose, my lord, it is true, my lord. I am thinking it is true. If it is intimated, it was intimated.
Writ petition was filed on 13th March 2025. This is a letter dated 6th September 2024. In between, if I find that before 13 March, these documents were transmitted to the present school, already it is found that the Provident Fund amount has been transmitted, then I will call for a report from the concerned DI. And if I find that these documents were transmitted before filing of this writ petition, then you have to face the consequences.
মানে kindly see the document.
I am asking you.
Kindly consider, my lord.
I am asking you.
Yeah, I've heard it. I heard it.
Yes, whether these documents were transmitted,
My lord, kindly allow me. If it is true, my lord, then no, give us.
whether these documents are transmitted or not, yes or no. You are moving this petition, you do not know. Withdraw this writ petition. Otherwise, I will impose cost after calling for a report from the DI.
Consider, my lord.
No, sorry.
Respectful submission, my lord. It is my respectful submission. Being a if it is so, my lord, it has been done, no grievance, my lord. The submission may be recorded by your lordship, my lord.
No, it is not so easy thing. You are wasting court's time by filing this frivolous writ petition. On a particular date, it is coming before this court.
Then no, my lord, grievance, my lord, is there, my lord. Kindly consider, my lord.
Issue.
My lord, kindly see the document. All the document has already been handed over to the Bagbaja school, my lord. Service book including all the documents.
What is this?
On my lord, 2nd of
At the
August
time
2005.
no, affidavit service filed on behalf of the petitioner is taken on record. Next paragraph. Learned advocate representing the petitioner submits that petitioner submits that the present writ petition is not being pressed. However, school authority of Purbo Khejurberia MC institution within bracket HS North 24 Parganas, comma, board and state respondents are represented by learned advocates. Next paragraph. In view of efforts submission made on behalf of the petitioner, writ petition stands dismissed as withdrawn, as not being pressed. Parties to act on the server copy of the order duly downloaded from the official website of this court. Take it back. Next.
Item number 6.
Lord, I appeal for the petition number.
Who are appearing for the respondents? Nobody is appearing. What is the matter about? When the service was affected? Find it out. There are no other parties apart from government leader. So what about the service upon the other respondents? 8. School authority. When? So why you have not served notice upon the government authorities apart from government pleader? What sort of service is this? It's not an appropriate service. In addition to effecting service upon the respondents, state respondents, notice is to be served upon the government pleader. What is this? You have to serve notice upon all the state respondents. In addition thereto, you have to serve notice upon the government. Issue. Take back the affidavit of service. Learned advocate representing the petitioner prays for accommodation to serve notice upon all the respondents. Stop. The learned advocate for the petitioner is directed to complete service of notice upon all the respondents, enclosing copy of this order by fortnight from date, and file further affidavit of service on the next date. And file affidavit of service on the next date. List the matter under the heading motion, or list the matter under the heading, under the same heading, on 6th May 2024, 2025. Stop. In addition to effecting service of notice upon the respondents, learned advocate for the petitioner is directed to serve notice upon the learned advocate representing the state respondents by 7 days from date. Next. Next. Yes. This is not an affidavit of service. File an appropriate affidavit of service.
Number 7.
I'm happy for the state respondent.
Yes. What is the matter about? Transfer. Yes. Then who is appearing for the commission and the school? No, first satisfy me on service. What about the service upon the school service commission? Commission of School Division. School Service Commission is not made party. When the transfer application was made,
After the making of application, the central school service.
show me the transfer application.
The offline transfer application.
Show me the offline transfer application. Mr. Acharya, you are not ready with the matter. You're taking so much time in the morning.
Page কত?
বুঝ উঠা। Where is the transfer application? Where is the offline transfer application? Then how the issue can be decided? That will not do. That will not do. Then I have to dismiss it. Mr. Acharya, I am dismissing is as not being placed. File an appropriate application, writ petition on the self-same cause of action. 64.
Then 64.
What is that? 63?
This is the application.
63. Page 63.
Wrongly submitted.
His writ
Lordship.
petition has 35 pages.
Incremental benefit matter, Lordship. Wrongly submitted. It is not the transfer application. তাই বলছি ভুল বললাম। বলছো তুমি, আমি তখন থেকে বলছি।
This is my lord kindly explain extremely sorry. This relates to my lord the
Incremental
incremental benefit. Both the 7 and 10 my lord same matter they wanted. But here my lord what happened my lord? I am the head.
Sure. At the time of call, it is found that the learned advocate representing the petitioner is not ready with the matter. However, state respondents are represented by learned advocates. Learned advocate, next paragraph. Hearing of this matter stands adjourned in order to enable the learned advocate for the petitioner to come better prepared. Next paragraph, list the matter under the heading motion in the monthly combined list of May 2025. Next.
Item number 8.
I'm for the petition.
Yes.
It's my all out. The transfer application page. Kindly come to page 81. It is pending at the end of the School Service Commission. Page 81. It is on the spouse medical ground and CMOH verification has been.
Yes, you have applied for transfer.
Yes.
Mr. Lahiri, it is on what ground?
It is on the medical ground of the spouse. CMOH verification has.
Spouse medical ground.
Yes. CMOH verification has already been done. DI has forwarded it to the commission. It is pending at the end of the commission.
Now, where is the medical report?
Page 25.
Page 25 onwards. Page 25 is the CMOH recommendation.
Fresh medical examination is not an appropriate medical report.
This is how it has been done for all. This is it has been
Appropriate
done.
medical report of 2022 medical report, appropriate medical report within certain time, where it will be opined that the nature of
There could be change in there could
nature
be
of
change in-
element is such that constant care and
There
supervision is
could be
required.
change of circumstances because she is using medication, of course. My lord, it is
State
application
is
at that point.
represented.
Yes, my lord, application of that point. of
Affidavit
time is to
service
be
filed on
considered.
behalf of the petitioner is taken on record.
Application of that time is to be considered. Subsequent my lord, it has gone.
Now, if you are cured, then what is the use of after 3? Why you are coming after such a long time?
Because extended time to time we have been waiting for this
Why,
decision.
till date it is suspended.
That is why, my
So
lord.
if you are coming after such a long time, you could have come after within a reasonable time.
But it has already been completed, my lord. CMOH verification.
Affidavit service filed on behalf of the petitioner is taken on record. Next paragraph. Petitioner, petitioner prayed for transfer since petitioner prayed for transfer on 17th August 2021. On 17th August 2021, on the portal, since wife of the petitioner was suffering from
That is 23rd
Gyno-
January.
17th August,
No, my lord. 23rd January.
it was sent to DI on 24th January.
No, application is a serial number 3. 20.
Serial number 4,
No,
Three,
3.
madam.
3.
HY to applicant,
That was a
applicant to
previous
HY,
application.
23rd January.
23rd January.
হ্যাঁ কি বলছিলেন? Gynecological disorder. Stop. Medical certificate is annexed at page 25 of the writ petition, wherefrom it appears wherefrom it at page 25, which is not exhaustive. Stop. Nothing is spelled out in the medical certificate dated 28 January 2022. That nature of ailment of the wife of the petitioner is such which requires constant care and supervision. Stop. Next paragraph. It is also submitted on behalf of the respondent authorities that medical certificate is of 2022, and in the meantime, due to constant treatment, wife of the petitioner, health condition of the wife of the petitioner may have been improved. Next paragraph. Having considered the submissions made on behalf of the parties and taking note of the medical certificate dated 28 January 2022, which is cryptic. District Inspector of Schools SC. Which district?
Yes, ma'am.
Mr. Lahiri, which district?
Yes, ma'am.
Murshidabad, madam.
Murshidabad.
District Schools SC Murshidabad, being respondent number 5, is directed to obtain fresh medical report on medical examination of the petition from the concerned Chief Medical Officer of Health / Medical Board by 4 weeks from the date of communication of this order. The Chief Medical Officer of Health / Medical Board is required to opine in the medical certificate. Is required to opine in the certificate that nature of ailment of the wife of the petitioner is such which requires constant care and supervision. Stop. If medical report justifies transfer of the petitioner, transfer application of the petitioner and along with medical report shall be forwarded by the respondent number 5 to the Chairman, West Bengal Central School Service Commission, being respondent number 4, by fortnight thereafter. Stop. On receipt of transfer application and medical report, respondent number 4 shall decide the same in accordance with law by 4 weeks thereafter. Next paragraph. It is made clear that suspension of portal shall not be a ground to reject the transfer application of the petition. Next paragraph. The writ petition stands disposed of urgent jurisdiction.
The different CMOHs have different formats. So in that format, they have
No, not format. They have
They
to
have-
opine.
separately.
Yes.
Different
I am
CMOHs.
finding that in a tabular form 1, 2, 3, 4
Mhm.
medical reports. That is not the
Different
purpose.
CMOHs have different
Yes.
ways. That is the difficulty. They are doing it in a different manner.
At the age of 40, 45, a person may not be medically fully fit.
Absolutely.
But whether the extent of illness is
so grave.
is such whether the requirement of transfer of husband has to be justified in the medical report.
Rule only says that much is required.
That I have said.
Yeah, that much is required.
Yes.
But I'm for the state.
Otherwise, why the husband will be transferred?
Yes, absolutely. Logically, that is correct.
Yes.
But the rule is not, is silent on that. Only that disease is there, you are eligible.
That's why court of equity is there.
Yes, iron out.
That's why constitutional court is there. Yes.
Iron out
Yes.
decreases.
Yes.
Absolutely. Absolutely. It has to be there. Has to be there.
Item number 9.
My lord, I am for the state, my lord. And this is the instruction.
And we have inputs that how these medical certificates were being issued.
There are certain things.
In other courts also directing that the officer of the education department and in the case, in appropriate case, lady officer should be deputed at the time of medical inspection, and a different medical report is coming thereafter.
Yes. No, the thing is 20.
So how these medical reports were procured, that we can perceive.
There is one thing.
Yes.
2020.
Is next matter.
Yes, I am for the petition.
My lord, in item number 9,
Please. May I just but kindly come to page 76. That is on general transfer ground. He is eligible.
Page 76.
76. It is pending at the end of the DI since portal has been temporarily suspended, and school has also given NOC at page 77. It is application dated 3rd February 2022.
Yes, it's an application on general ground.
General ground. It is pending at the end of the DI due to temporary suspension of the portal, but it has not been at 70.
Distance ground.
Yes, 77 is.
Then you made application on 3rd February 2022.
Yes, my lord.
Then it was forwarded to the DI.
DI. 77.
Now why DI is not forwarding it?
my lord, this is what
Yes, you tell me. I have not called for any report. You go through this and make submission.
my lord,
It's not a case diary in bail matter.
actually, as the transfer process is temporarily suspended, except the process of mutual transfer by the school education department, secondary branch, government of West Bengal, and as transfer application of the petitioner is lying at the end of West Bengal School Service Commissioner, it is hardly possible for this office to intervene in the matter because of the decision is pending at the end of higher authority. So that is what the instruction.
You are not a single teacher in the school.
No, not a single teacher. It has been, my lord, the one thing, my learned
This
friend
is
has submitted has gone to the commission. But
instruction.
my possibly subsequent, since I have no access to the portal, maybe it has been sent to the commission. I am not aware of that.
কতজন টিচিং নন টিচিং স্টাফ আছে বলেছেন কিছু? না না আপনার রিপোর্টে আছে স্টাফ প্যাটার্ন
রিপোর্টের স্টাফ প্যাটার্নটা দেয়নি মানে খালি ওরা দিতে পারছে না।
Yeah, petitioner is a headmaster.
I'm just confirming, my lord. Possibly, yes.
সেটা দেয়নি তো, সেটা দেখলাম না, আমি পড়লাম তো দেখলাম না।
With effect from 5th July 2011.
9th June 2011. Yes. Recommendation was it.
Headmaster of a school. What will
Permitted,
happen
permitted in the law.
to the school authority?
I'm only within the periphery of law. It will be filled up by others. Some other person will come.
So now filling up posts are really difficult because 26,000 effect is there. Kindly also consider that as
Those are not headmasters.
I know.
Those are assistant teachers. There's a substantial difference.
This is like this.
Then why this 26,000 is coming?
সেটা বলেনি এখানে কতজন আছে সেটা তো না দিবেন, রিপোর্টেও নেই।
হেডমাস্টারের ক্ষেত্রে না হেডমাস্টারের ক্ষেত্রে স্টুডেন্ট টিচার রেশিও হয় না, অ্যাপ্লিকেবল হয় না।
না অ্যাসিস্ট্যান্ট টিচার হিসেবে অ্যাপয়েন্টেড হয়েছিল, তারপরে
নেক্সট যে টিআইসি হবে সে
যদি 10 জনই চলে যায়
তাহলে কি করবে?
তখন হবে কি করে?
তো সেই ফ্যাক্টসটা নেই, রিপোর্টেও নেই।
স্কুলে ঘন্টা বাজে লোক নেই
হুম,
স্কুলে যাবে সেখানেও তো নেই।
এটাই বুঝছি।
আরেকটু দিতে ফেলছে, অসুবিধাটা কত? হেল্পই হবে।
সবাই ট্রান্সফার কোথা থেকে দেবে?
ভাবি আলটিমেটলি কি তো চলবে।
আপনাদের তরফ থেকে কিছু ইনস্ট্রাকশন দেয়নি?
AI এর end এ আছে।
না না ডিআই তো রিপোর্ট দিয়ে দিবে এটা যেহেতু ইয়েতে আছে।
স্টুডেন্ট টিচার রেশিও
হুম।
পাঠিয়ে দিয়েছে, পাঠিয়ে দিন আপনার এন্ডে করে আছে। উচ্চশ্রী পোর্টাল সাসপেনশন
But
বলেছি
TI has said that after incorporation of Utsotsri portal scheme, the petitioner applied for general transfer on 3rd February 2022 through Utsotsri portal and on 8 February 2022, transfer application of the petitioner has been forwarded to the DI. Forwarded by the DI, Nodia to the West Bengal School Service Commission.
Then,
Let them
that is
take a
not showing in the
decision.
portal. So
Yes.
if that be so,
Let
portal
them-
is there,
Yes.
portal is not showing.
Portal is because we had no access to that afterwards. It is up.
Yes, 8 February 2022. It was sent to the West Bengal Central School Service Commission, checked and verified. It was forwarded to.
Lordship is.
Then I shall take it.
Let it be decided by the commission.
Your lordship will direct.
Issue.
তাহলে আরেকদিন
ওটা দিয়ে দিন।
ওটা
Affidavit service filed on behalf of the petitioner is taken on record.
জেরক্স আমার কাছে নেই। আমার কাছেও কপি
No, এই type.
আমার কাছেও নেই।
Petitioner is the headmaster of a government aided
আমি জেরক্স
school,
করাচ্ছি আমি
government aided recognized school who applied for transfer on 3rd February 2022
দেখাচ্ছে পাঠিয়েছি
on Utsotsri portal.
হুম
It is
পাঠিয়েছি
also
কিন্তু-
submitted by the learned advocate representing the petitioner
আমি জেরক্স করাচ্ছি তাহলে
that on
করিয়ে দেবো।
3rd February
ফোন
2022,
নাম্বার
এটা দাঁড়ান না, আমার
school authority where petitioner is presently working forwarded the transfer application to the district inspector of schools, AC concerned, for taking further steps.
আমার কাছে কিন্তু নেই কপি খালি আমার junior
It is contended on behalf, it is further stop. It is also contended on behalf of the petitioner
আপনার দাদা একটু নাম
that till date, after forwarding the transfer application by the school authority to the concerned district inspector of schools, no steps have been taken.
একটু করুন।
Stop, next paragraph. However, from the communication dated 3rd April 2025 of the district inspector of schools, AC Nodia, it appears, Nodia, a different picture appears. Stop. It is stated by the district inspector of schools within bracket AC
জেরক্স
Nodia
করাবো তো।
that on 8 February 2022, transfer application of the petitioner was forwarded through portal to the West Bengal Central School Service Commission for taking decision. Stop. However, it is also stated in the communication dated 3rd April 2025 that decision could not be taken due to suspension of portal. Next paragraph. State respondents and comma West Bengal Central School Service Commission or state respondents and West Bengal Central School Service Commission are represented by learned advocates. Stop. It is submitted on behalf of the commission if transfer application of the petitioner was forwarded by the concerned district inspector of schools within bracket AC on 3rd February 2022. In that event, chairman of the commission may be, in that event, appropriate authority of the commission may be directed to take decision on the transfer application in accordance with law. Next paragraph. Statutory right of a teacher seeking application cannot be denied on the ground of suspension of Utsotsri portal. And the issue is no more res integra in view of the decisions taken by the Honorable Division Bench and this court in similar other matters. Next paragraph. Stop. Next paragraph. Hence, Chairman West Bengal Central School Service Commission being respondent number 4 is directed to decide the transfer application of the petitioner by 6 weeks from the date of communication of this order and the decision to be taken by the respondent number 4 shall be communicated to the petitioner by 10 days there. Next paragraph, it is made clear that suspension of portal shall not be a ground to reject the transfer application of the petition. Next paragraph, writ petition stands disposed of. Then you have to-
My lord, in other matters, your lordship, since those were application of long back, those schools may not be available today. So, my lord,
No, it's a
option
case of headmaster. Let them take decision.
options may be given because at that point of
No.
time. Grateful.
Yes.
Item number 10.
Item number 10, Lord, I append for the
I am for the state lordship in this matter, my lord.
Yes. Issue. Petitioner is willing to withdraw the writ petition with liberty.
Lordship.
At the time of call, learned advocate representing the petitioner learned advocate representing the petitioner submits that petitioner does not submits that petitioner does not wish to proceed with the writ petition, or petitioner wants to withdraw the writ petition. Petitioner wants to withdraw the writ petition with liberty to file afresh. Next paragraph, state respondents are represented by are represented by learned advocates. Next paragraph. In view of aforesaid submission, writ petition stands dismissed as withdrawn with liberty to file afresh with better particulars on self-same cause of action. Parties to act on the server copy. Next.
Grateful, my lord.
Item number 11.
Time for the petition.
We have a state, my lord.
My lord, transfer application made on self-medical ground.
Commission.
Served.
School.
Also. It
When
has gone
served?
up to the DI.
When served?
School received on 7th of April. And commission previously.
9, today we are on 9th of 10th of April.
See, delivered 7th. 48 hours is over. It is, my lord, it has gone to the DI medical. Kindly come to page 97 for one.
Issue.
Only the medical board is to be constituted. It is at that stage.
At the time of call. No, get it out. Affidavit service filed on behalf of the petitioner is taken on record. Stop. Today, school authority and state respondents are represented by learned advocate. Stop. Learned advocate for the petitioner is directed to serve notice upon the non-appearing respondents or the learned advocates representing those respondents by 7 days from date and file further affidavit of service on the next date. Next paragraph, list the matter under the same heading on 6th May 2025.
I'm grateful to Lord.
Next.
Item number 12.
This is my evidence. Petition is the approved clerk of a university in a madrasa type. My lord, department in service is approved, but some area salary has not been paid. Well, it is evident from the letter of the district.
What about the service upon the madrasa?
Well, the service complete.
When you have served?
My lord,
Director of Madrasa Education, District of Minority Affairs, 3rd April. Yes. What is the you are seeking direction for release of arrear salary?
It is admitted by the state authority.
Where is that relevant memo of the TI?
Annex P3, my lord.
P3.
Page 20.
Resolution come.
It is here. Okay.
Yes.
You moderated 10th March.
Just a minute. Why this area accrue?
Dear accrued, my lord, as far as he was appointed as organizer teacher, my lord, thereafter his appointment has been approved.
Where is the approval?
My lord, annex to page 20.
P2, page 20.
Page 20.
Now, 2022, this approval was granted from 14 July 2010. No, 19th October 2022, page 20.
From 14 July 2000.
Why from 12 years back this approval was granted?
Kindly bottom. It is, my lord, 19/10/2012, my lord.
No, 22, 19, 10, 2022.
এটা তো 22 আছে।
No, no, 12.
Director of District Office of Minority Affairs, Purbo Medinipur, 19th October 2022, not 12.
12, my lord.
So why 12 years back
No, my lord, kindly-
effect was given
Kindly
from a
bottom,
retrospective
bottom
effect
six.
from 2010?
And it is 12, my lord. The bottom, my lord, signature.
At the top, my lord, it is 19th October.
See my document, there is no 12.
My lord, this is
That's true, my lord. At the top one it is 22, but in the bottom it is 12.
Where?
my lord. 12, my lord.
এটা উপরেরটা উপরেরটা দেখো 22 আছে।
আর নিচে, my lord.
দেখি কোথায়? No, this is 22. Where from you are getting 12?
My lord, even my,
No, it is 22.
my,
Read it carefully.
my lord,
It is not 12.
in my portfolio.
See, it's not 12.
উপরে দেখো
It's not 1, it's 2.
উপরে এটা পরিষ্কার 22, এটা কোনো সন্দেহ নেই।
And may I get the original copy, my lord? Original.
Yes, show me the original copy. Why my query is why retrospective effect has been given from 2010, 12 years back. This approval?
My lord,
Do you have any instruction?
No, my lord, I have not at present, my lord, because my lord, director of Madras Education is out of station due to some medical problem, my lord. And kindly fix it, my lord, next
No, it's
Thursday.
a District Minority Affairs, Purbo Medinipur has issued this order.
But my lord, the director of Madrasa is the competent authority to release the amount, my lord. And they also admitted, my lord, then it is the genuine case, my lord.
It's an order of DOMA addressed to the Director of Madrasa Education. Now, court wants to know that this approval memo was issued on 19th October 2022. It's not 12.
No,
It's
no,
22.
It is 22, my
If
lord.
19th October 2022, this approval memo was issued.
Yes.
Now, why this approval was granted from 14 July 2010? What is the reason behind that?
I will come back, my lord, with that instruction, my
my
lord.
lord, I also being the original, my lord, approval memo. my lord.
Issue.
He was appointed in
Affidavit of
the year
service filed on
1999.
behalf of the petitioner is taken on record. Next paragraph, petitioner has prayed for release of arrear dues as for the period as stipulated in memo dated 10th March 2023, which is at page 21 of the writ petition. Stop. However, on perusing approval memo dated 19th October 2022 issued by the District Officer for Minority Affairs, Purbo Medinipur, it appears, কি বললাম সেন্টেন্সটা? However, so and so, it appears that on
এটা
19th
তোমরা কারেকশন
that
পরিষ্কার 22 আছে।
approval was granted in favor of the petitioner as clerk of Madrasa Shiksha Kendra, as a clerk of Madrasa Shiksha Kendra from 14 July 2010. Stop. On posing query to the learned advocate representing the state respondents, he has prayed for accommodation to obtain instructions. Next paragraph. List the matter under the heading motion on 29th April 2025 in order to enable the learned advocate for the state respondents to obtain instructions. Next paragraph. Learned advocate for the petitioner is directed to serve another notice enclosing copy of this order upon respondent number 5 by 7 days from date, and file further affidavit of service on the next step.
By
Number 5. 5 মুখ্য শিক্ষা সম্প্রসারক
my lord.
Next.
Grateful, my lord.
Item number 13.
13, my lord, I beg to appear for the respondent number 5, school. One school. There are 2 schools are involved, one school, Moesta.
You are for the state.
Yes.
Before my learned senior can start, my lord, I draw your lordship kind attention to the maintainability of the writ petition.
Yes, it is also barred by
issue
red
has
petition.
been already decided by an order dated 1st February 2024, appearing as page 18. And the writ petition has been pleaded on the ground as a review or appeal to that order, and from the abutment it's appearing. Already the issue, my lord, your lordship come to page 18.
Page 18.
Page 18.
And may I read for you?
My lord, may kindly have a look of the page 17 earlier.
Input করছে।
হ্যাঁ, report meeting হয়েছে।
abutment তো নিয়েছে as a review and
Yes, how this writ petition is
My lord,
maintained.
kindly come to page 20, my lord. I have not got, my lord, my lord, benefits.
For that, you have to prefer an appeal. But further writ petition is not maintained.
Sir, kindly
in view
come
of
to
the
page
order dated
21.
1st February
My lord,
2020.
earlier-
Please.
My lord, earlier, page 20,
Because
my
the
lord.
coordinate bench has decided that has found that your grievance is redressed.
My lord, page 20, my lord.
Then you
kindly
have to prefer a review before that bench.
My lord, kindly-
Once it has been decided
my lord,
and
another, my lord,
a writ petition has been disposed of, expressing satisfaction that your grievance has been
but
redressed,
my respectful
this writ petition cannot be considered.
my respectful submission is that my, at that point of time, my lord, my running advocate also told asked my lord before the bench, my lord, that for the interest and other things, my lord opined that you have to file a fresh writ petition.
Where
Though
is-
my- though-
where
though
is that
it
opinion?
That is not written, my lord, but it was my instruction.
I was-
Then you have to-
my lord,
Then you have to file a review or appeal.
my lord,
Writ
kindly come
petition
to
is not
page-
maintainable.
Yeah, my lord, kindly come to page 58, my lord, fresh representation I have given, my lord.
No, that is not permissible.
My lord, kindly.
My lord, that
kindly
thing was
directly
not done.
consider
My
that-
lord, I also appeared in that matter also.
Just a minute.
My lord.
here I am.
Page 20, my lord, kindly. And earlier writ petition also, my lord, kindly see.
Issue. Affidavit service filed on behalf of the petitioner is taken on record. Next one. Petitioner has claimed release of arrear unpaid amount due to his superannuation from the post of headmaster on 31st October 2015. However, during course of hearing, it is brought to the notice of this court that the issue was considered by a coordinate bench in connection with the writ petition being WPA 13663 of 2021, and an order was passed on 1st February 2024, which is at pages 18 and 19 of the writ petition. Stop. On perusal of the order dated 1st February 2024 passed by the coordinate bench, it appears that considering the respective submissions made on behalf of the parties relating to payment vis-a-vis non-payment of arrear dues, it was recorded that the grievance of the petitioner was found to be redressed. Stop. Stop. In view of the order passed by the coordinate bench on 1st February 2024, present writ petition is barred by res judicata and the same is not maintained. Stop. Hence, the writ petition stands dismissed. Next.
Liberty given.
No, certainly not.
Item number 14.
Item number 14.
Yes.
As an officer of the court, my lord, I would like to point out one thing before the matter is taken up. The issue in this challenging this writ petition has already been decided by a coordinate bench in 2021, with a judgment dated 16th of March 2021. Your lordship has appeared in the matter for the state respondents in that. If your lordship wants to peruse that judgment, my lord, I have the
Yes, please place the case. Let me see.
lordship.
Yes.
The petitioner herein has challenged the decision of the school education department that HRA should be HRA was stopped. House rent allowance was stopped.
That Mousumi Bishwas's case.
Lordship, Mousumi Bishwas.
So so petitioner is not getting HRA.
Lordship, the spouse of the petitioner is a private concern employee and getting HRA. In view of that, HRA was stopped. Challenging that, this writ petition.
So the petitioner is not in receipt of HRA since husband of the petitioner is receiving HRA in connection with his service in a private organization.
Private organization.
So we are relying upon the judgment of Justice Shekhar B. Sharaf. Hey, release করে দেবে usual HRA. House rent. Take it back. This will help. To take back the affidavit service.
Item number 15.
Teacher has paid for transfer.
You have prayed for transfer
On
the portal,
on the not portal, the offline,
on medical ground.
medical ground. He is a gynecological patient, and
Yes, he is
gynecological patient. He is a
gynecological patient.
problem.
Who petitioner or the wife of the petitioner?
Petitioner.
Where is your transfer application?
Page 20 onwards. 21 is the page.
So the school authority has given no objection.
Yes. Yes. Page 24. Page 24. Yes.
Your application starts from page 21 in the prescribed
21.
form.
And 20, my lord, my lord,
Just a minute.
Right. Is the forwarding letter 20. No objection, page 24.
Now it is lying before the DI.
Yeah. DI, my lord,
DI has to obtain, have you obtained medical report
No, my lord.
on medical examination of the petitioner?
No, lord. Still
Yes.
no instruction have been received, my lord, from the GI. Let it be adjourned by 1 week. In the meantime, I shall take the instruction
DI
from
to
this,
take it
from the.
after taking.
When you have applied?
My lord, on 10th, my lord, the 11th, my lord, to page 20, 11th February has received by the DI.
11th
February.
February.
Eligible, my lord,
Forwarded this application to the district inspector of school.
Yeah.
The rule says, my lord.
No, it's a transfer offline application. Offline application, that's why not through portal.
Not through portal, but the application must be submitted before the.
But the school has given no objection.
The original application, my lord, should have been forwarded before the district inspector of school. My lord, kindly turn to page 21. My lord, it's, my lord, addressed to the Chairman Central School Service Commission as well as the district inspector of school.
No, what is the date of your application?
my lord, 10th February, my lord, here, my lord, written, my
The
lord,
school has given no objection on 29th of January 2025.
and 10th February, my lord, I have applied, my lord.
Where is the date?
My lord, the paragraph 6 I have stated, my lord. Paragraph 6. Paragraph 6. And
10th February.
10th February. And 11th, my lord, has received by the DI, and 11th and 11th also received by the SSC.
So let it be decided, first you obtain the medical certificate. If medical certificate medical report justifies your transfer of the petitioner, forward it to the commission. Affidavit is filed on behalf of the petitioner is taken on record. Next paragraph. Client advocate representing the petitioner submits that a transfer application has been made by her on 10th February 2025. 10th February 2025 in the prescribed format, and the school authority where petitioner is presently working has given no objection on 29th January 2025 for petitioner's transfer. It is further submitted that transfer application was submitted before the district inspector of schools. When you have submitted before the DI?
11th February.
Where you have stated?
Page 7.
Page 7.
Para 7.
Para 7, my lord.
Page 5. Page 5.
Page 5.
Page 7.
No, page 5, paragraph 7.
Yes. Say the application was
Received by the respondent on 11th February.
Personal service.
Yes.
So where is the receipt?
More, I have annexed page 20. Well, these are illegible. These are not original.
আচ্ছা কি বলছিলাম? On 11th February 20 district inspector of schools concerned district inspector of schools AC on 11th February or district inspector of schools AC on AC Murshidabad on 11th February 2025. But thereafter no steps have been taken. Have you been medically examined? No, whether you have been medically examined or not.
No.
Achha. Have been taken by the concerned respondent authorities for processing the transfer application of the petitioner. It is also submitted by the learned advocate. It is also submitted on behalf of the petitioner. Till date, petitioner has not been medically examined by the concerned medical officer. Next paragraph. The district inspector of schools AC Murshidabad being respondent number 4 is directed to obtain medical report on medical examination of the petitioner by 4 weeks from the date of communication of this order. By 4 weeks from the date of communication of this order from the concerned chief medical officer of health or /medical board. In the medical report, Chief Medical Officer of Health / Medical Board is required to opine whether nature of ailment of the petitioner is such or is required to opine, is required to opine considering the nature of ailment of the petitioner. C is required to avoid long distance journey. Stop. If medical report justifies transfer of the petitioner, respondent number 4 shall forward the transfer application along with medical report to the Chairman West Bengal Central School Service Commission, being respondent number 3, by fortnight thereafter. Stop. On receipt of medical report, Chairman West Bengal or on receipt of medical report, respondent number 3 shall decide the same in accordance with law by 4 weeks thereafter. Stop. The decision to be taken by the respondent number 3 shall be communicated to the petitioner by 10 days thereafter. Stop. Next paragraph. It is made clear that suspension of portal shall not be a ground to reject the transfer application of the petitioner. Next paragraph. The writ petition stands disposed of. Urgent xerox. এটা দিয়ে দাও। Next.
Item number 16. In this matter, my lord, I am appearing for the petitioner, my lord.
In this matter, I am for the state respondent, my lord.
The case, my lord, of transfer, my lord. Petitioner is an approved headmaster of his school, my lord. He submitted an application for transfer, my lord, through Uchusi portal, my lord.
Where is the status of the transfer
28, my lord. Page 28, my lord.
Page 28?
Yes, my lord. Then, my lord, school authority taken a resolution to the effect, my lord, that if the petitioner transfer to another school, my lord, they will have no objection of it, my lord. Then, my lord, school, my lord, forwarded the application, transfer application to the DI, my lord. But till the DI has not forwarded the same to the School Service Commission, my lord. Similar matter, my lord, came before your lordship, my lord, then your lordship passed this out.
Which for the state?
My lord, I am for the state.
Why the DI has not forwarded it?
My lord, at present, my lord, Uchusi portal is, my lord, suspended. And
Any other ground?
And any other ground, it is a, my lord, at page 30, my lord, application for general transfer. And the distance is, my lord, only 30 kilometer, which is stated at in.
But that is beyond 25 kilometer.
25 kilometer, it is 30 kilometer, my lord.
So therefore, it is not, there is no bar. If distance is.
Your lordship is right. But, my lord.
Is that, my lord? My lord, probably petitioner has applied for transfer the medical ground of his house.
No, it is not in the transfer application, it is general transfer. Please come to page 30.
Actually, distance.
Paragraph 11 is 30 kilometer.
30 kilometer, and the wife is chronic patient of the marriage.
That is
not
the other reasons, but that is not the reason which is disclosed in the transfer application.
Lordship.
Transfer application is made on the ground of distance. Now, if the distance in between the two schools is 30 kilometer, or then that there is no bar, it is because the cap distance, the distance which has been specified under the rule is 25 kilometers.
25. Lordship is absolutely.
So why DI is not taking steps?
I will kindly pass the appropriate direction so that it can be considered. In the meantime, my lord, at point of time, Uchusi portal also, my lord, suspended since last.
Affidavit service filed on behalf of the petitioner is taken on record. Stop. Learned advocate for the petitioner applied for transfer on Uchusi portal on 19th September 2022.
Oh, the date of suspension, on the date that was suspended. There from the date of application. On the date of application, Uchusi portal was suspended.
And same was forwarded by the school authority where petitioner is presently working as headmaster to the district inspector of, to the concerned district inspector of schools within bracket AC for taking further steps. Stop. Grievance of the petitioner is in spite of receipt of transfer application through portal. The district inspector of schools within bracket AC, or given the grievance of the petitioner is of transfer application on 28 September 2022. The district inspector of schools AC did not forward the transfer application of the petitioner to the West Bengal Central School Service Commission for taking decision. Stop. Petitioner prays for direction upon the concerned respondent authorities for consideration of his transfer application. Next paragraph, respondents are represented by learned advocates who have jointly submitted that contemporaneous decision on transfer application could not be taken due to suspension of portal.
Lordship.
Next paragraph. However, it is submitted on behalf of the Commission, West Bengal Central School Service Commission, if direction is given upon the appropriate authority of the Commission, same transfer application of the petitioner shall be decided in accordance with law. Next paragraph, having considered the submissions made on behalf of the parties, writ petition stands disposed of, directing the chairman, West Bengal Central School Service Commission. Which chairman is a party?
Yes.
Which respondent?
Respondent number 3.
No, it's a commissioner of school education.
Yes, you will forward. My lord has passed the order to transfer.
Very well. Where is where the commission is a party?
Commission, School Service Commission. My lord, 3 is West Bengal Central School Service Commission. Respondent number 3.
3.
Yes, my lord.
Service through the chairman. আচ্ছা ঠিকই বলেছো ওটা দেখো তো কোনো সেন্টেন্সটা না আগে প্যারাগ্রাফটা বাকিটা সব কেটে দাও however it is submitted on behalf of West Bengal Central School Service Commission that till date transfer application of the petitioner has not been forwarded by the district inspector by the concerned district inspector schools AC North 24 Parganas being respondent number 4. Stop. It is also contended that if transfer application is forwarded, in that event, appropriate steps shall be taken for consideration of the transfer application. Next paragraph. Having considered the submissions made on behalf of the parties, writ petition stands disposed of, directing respondent number 4 to forward the transfer application of the petitioner to the respondent to the chairman West Bengal Central School Service Commission being respondent number 3 by fortnight from the date of communication of this order. Stop. On receipt of transfer application, respondent number 3 shall decide the same in accordance with law by 6 weeks thereafter.
Lordship.
Stop. The decision to be taken by the respondent number 3 shall be communicated to the petitioner by 10 days thereafter. Next paragraph. It is made clear that suspension of portal shall not be a ground to reject the transfer application of the petitioner. Urgent Xerox certificate copy disposal board release. Yes, next matter.
Deep glory.
Item number 17.
Page 57, Madam Pankaj.
Page 27.
First application made by the petitioner to the Commissioner of School Education on special ground. Because at that point of time, the School Education Department issued a circular entrusted upon the Commissioner of School Education to take care of those transfer application against special ground. Page 57.
Page 27.
57, Madam. 57.
বলে দেবো
Yes, page 57.
Prayer for general transfer on special ground. That's it, got it?
Yes, but it is not in prescribed format.
Yes, well, at that point of time, there is a government circular entrusted upon the Commissioner of School Education to look into the issue regarding the special transfer. That's why this application was made to the Commissioner of School Education. Well, there was no response. Well, in doing this application, I have next page the prescribed format. Can you see the next page the prescribed format?
Yes.
This was given to those applications, but there was no response. Well, thereafter,
When it was given? When this special application in the prescribed pro forma was submitted before the authority?
27th of January 2021.
So why you are coming after 4 years?
No, my lord. Earlier I approached this number, but I am coming. My lord,
Yes.
but next, since there was no response, petitioner filed another application on page 64.
Page 60.
This application was made as per instruction of the school authority. The petitioner's son is suffering from autism spectrum disorder and also more than 75% disabled. Since
That is dated August 2022.
yes, ma'am. That was forwarded specified by the school authority to the page 68. 68.
It was also in the offline mode.
No,
Page
this online.
64.
This was in the online.
68 is the portal.
This portal position is there, page 68.
68.
My lord. It was forwarded.
So this application, which is at page 64, was made on the portal.
My lord. Page 60, it was forwarded saying that
When the application was made.
this application was made on 9th August 2022. At the bottom, my lord, that my lord, page so statement.
এইটা রিপোর্ট দিয়েছে তিনটে স্কুলে পাঠিয়েছিল স্টেটমেন্ট কোথায়
Thereafter, I approached.
Just a minute. But this is an application on distance ground.
Yes, my lord, kindly see this copy
Page
of the-
64.
Yes, my lord. I have been teaching in your institution for over 9 years, and now I am facing some problems due to distance and other family matters. Since the autism spectrum disorder was not covered,
There
in
is
the
single
specified-
teacher in the school in English. And this application is on a distance ground.
No, my lord, and the other family matters, because the autism spectrum disorder.
Nothing
was
is
not
spelled
there.
out in your application.
Yes.
It is an submission made at the bar.
My lord, kindly use my first application. My lord, kindly see
No, no.
the first
Court has
application.
to consider based on your application,
My lord,
not
perhaps,
beyond
my lord,
that.
earlier occasion while
That was
placing this-
before another authority.
my lord, perhaps
I have
while-
to consider the application at page 64.
Yes, that's why, my lord, subject to correction, my lord, I was not there earlier. My lord, perhaps while pressing this application, my lord, it was
So
not
that's why
applied.
DI has rightly said, and
was
school
not
has said that you are the only teacher in English.
was-
DI has said that there is a requirement to
Lord, I
follow
have seen, I have
3rd January 2022
Only
notification.
thing, my lord, while placing this earlier writ application, perhaps it was not apprised this court that petitioner's original application was on the ground of a minor's sons, because he is suffering from autism respect.
Maybe, but that was before the different authority. You have not pursued before for consideration of that previous application. Now you have made a separate application on the portal. That application is on the ground of distance. How this can be considered if it is not on the ground of on medical ground?
Any other grounds, any other grounds.
What ground you have to indicate? It may be that the petitioner is divorcee. It may be petitioner is being prevented because of other reasons. It may be there is a physical disability of the petitioner. Nothing is spelled out.
Yeah, my lord, say granting 1 day time, but there is a division bench time. Any division bench judgment is there. Or it is division bench observed that any other grounds means not only the distance. It also covers some medical grounds which is not the specific.
I have delivered a judgment that any other ground is to be considered as ejus dim generis.
Yes.
So therefore, the grounds under E has to be similar to the grounds which are stipulated in A to A, B, C, A to D.
Kindly see
So
the
therefore,
subject.
your application.
Subject of my prayer, kindly see the page 64 at the top. Subject for granting general transfer application on other reason.
You have to satisfy, because other reasons is a connotation which has a meaning which cannot be attributed. Meaning cannot be attributed which is contemplated under 4A. Under 4A, there is a specific reason, specific ground which is medical ground. What prevented you to take such ground at the time of making application?
Because autism is not a specified disease. That's why.
That court could have considered. It's a medical ground application. Where is your application on why your application is silent? What prevented the petitioner to take the point of medical ground?
Yes, Malad, that's there, Malad. But the first application, I have specified everything. Malad.
First application is dead now. So application of 2021, by making a subsequent application, first application has no is not alive. You have filed another application that is on the ground, primarily on the ground of distance and other family matters.
Yes.
Why other ground? You could have stated in your application that the son of the petitioner was suffering from autism.
It would have been.
I have passed several orders
And Malad,
as a special case, but that nothing is spelled out.
Petition also disposed of on the ground of
Yes, Malad, that's a
Distance.
Page
Malad, that
69.
nobody apprised this on court that
Page 60.
9. Petitioner moved this for court and your lordship has directed in terms of 3rd January notification. If it is a fifth case, local arrangements should be made. Page 71 is the
Page 69.
Yes, ma'am. Operating part is page 71.
And my lord, the DI has said.
Just a
three
minute,
proposals.
please wait.
Yes.
So already I have passed an order.
That's I have said, Malad. While
And in the
passing,
next
while
page,
placing
page
this in the
72,
application,
DI has
perhaps nobody apprised this honorable court that Malad, the actual application is on the ground of
Yes.
his petitioner's Malad son.
How this
autism.
repetition is maintainable then? Yes.
Malad, thereafter, Malad, they passed an order, Malad. Malad, page 72.
No, but considering this, your same application for transfer, I have passed an order.
No, so I have
So how this
I have
repetition is
said so.
maintainable?
Malad, subsequently, they have passed an order. Malad, they said that
Sir,
we are
now can you turn around and say that no, this application should be treated as an application on medical ground?
on the ground because
Can it be done?
Malad, on-
Once an application was made, this was writ petition was moved on the ground of distance. Application on the ground of distance. Court passed an order based on such application, directing the authority to follow notification dated 3rd January 2022. Now that notification, ultimately an appropriate order was passed by the district inspector of schools. The local arrangement could not be ensured.
Yes, ma'am.
Now,
That's why-
now can you turn around and say 360-degree, taking a somersault that this application, which was considered by this court and the writ petition was disposed of, now to be considered as an application on medical ground or any other ground? How much cost is to be imposed, Mr. Bari?
Malad, my prayer, Malad, kindly hear me. My specific case is that while
Can it whether this option, this window is open to you now? I'm astonished to see you have not joined the profession yesterday.
My plea
I have heard you enough.
Malad, my plea was that Malad, while placing that writ application, but nobody apprised that petitioner's original.
So for that, another writ petition has been filed, can be filed on based on the same transfer application.
Malad,
Under what
lordship
provision?
The lordship can more.
First of all, now, after this writ petition was disposed of, on 28 August 2024.
Proper fact is not brought to your lordship's notice. Lordship has the
For
power.
that, you have to file a review petition. Another writ petition.
Before
After
that,
disposal,
if
and
you
then there will be no end of the proceedings.
The authority have already passed an order to considering by Kubra. That's why I filed the writ application. If
You have you make an application seeking a particular relief. That application was not considered. A writ petition is filed for non-consideration of that application. Writ petition is disposed of, directing the authority to take decision on the basis of application. Authority takes a decision, which is not takes a decision not redressing your relief. Your prayer is not granted. Now, can you go back to your application saying that I have prayed for consideration of representation on ground A. Now, considering this, taking into account the same representation, please consider my case on ground B.
Read court, your lordship has the ample power to.
What you are submitting, Mr. Buddy? If you go on submitting, then I have to consider payment of cost.
Before the proper picture was
No,
not
no,
brought to the
no,
commission.
that is not the issue. There is a direction by this court to consider the representation. Or in this case, directing the authority to dispose of the application seeking transfer. That transfer application was considered as a transfer application on the ground of distance. That has been decided in the light of 3rd January 2022 notification. That could not extend any benefit to you. Now can you file another writ petition based on the same transfer application?
But since they have already passed.
Can you do
the order,
this?
that's why I
Yes
asked.
or no? I want to see. Can you do this?
I am leaving to your lordship. My lord.
Will you withdraw the writ petition, or I will? Yes.
I'm withdrawing.
Then otherwise I will not hesitate to pass an order, appropriate order.
Liberty to file appropriate application. My lord.
That liberty is always there. Here I will not grant any liberty. Is it an appropriate steps taken, legal steps taken by the petitioner? A transfer application on ground A that was directed to be disposed of by the authority. The authority has disposed of that transfer application. It is correct that no relief was granted to you. Now you can take a somersault and say, no, that transfer application should be considered on ground B, not on ground A.
That application was considered as per your lordship's direction. My
Is nothing but a volte-face so far the petitioner is concerned.
Since your lordship was not aware, perhaps was not aware that the petitioner's original.
For that, you should have preferred a review petition. That this could not have been properly apprised before the court.
Yes,
So fresh writ petition, fresh writ proceeding.
that was my contention. Madam.
What is this? What is going on? Issue. Again, I am asking you whether I will decide the issue.
No, but I am withdrawing this application.
At the time, during course of hearing, learned advocate representing the petitioner submits that petitioner is not pressing, submits that writ petition is not pressed. Submits that writ petition is not pressed. Stop. Respondents are represented by learned advocates. Next paragraph. Writ petition stands dismissed, not being pressed. Parties to act on the server copy of the minutes. New concepts are being developed. You could have preferred an appeal before the division bench. So this is not an appropriate case made out.
First an order, pursuant to lordship's order.
You took chance, got the order from the authority. Now you are saying, no, consider my transfer application not on ground A, but on ground B. Now when ground B will be disposed of, no, that is not the correct stand. So my transfer application should be decided on ground C. And court will go on passing one after another order, based on which School Service Commission will go on passing order.
Why I filed it. Otherwise, I could have filed the review application.
You should have given an appropriate advice to your client. Don't put on responsibility, all responsibility on your client, since you are moving this writ petition, holding vokalatnama. Yes.
Item number 18.
18, my lord, I am for the petitioner.
I'm stating.
My application for CPF to GPF.
For what? CPF to GPF conversion? You are seeking what?
My lord, I am seeking my lord arrear pension. The pension was granted to me from the date of my lord.
Do you have the copy of the order, which I normally pass in this mass? Assistant teacher.
Assistant.
You are for the state?
Yeah.
When superannuated?
He superannuated 31st August 2002. August 31, 2013.
31st August 2000. Where you have stated? সুব্রত বড় বিশ্বাস
Page,
আচ্ছা,
paragraph
দিচ্ছি,
9, my
দিচ্ছি।
lord. Paragraph 9 at page
Yes, yes.
5.
31st August 2002.
Yes.
এটা অ্যাসাইন্ড হলো আর রিলিজ pension payment order date.
March 31, 2015.
Which page you have annexed the PPO? Page
16.
Thirty-first March 2015.
Yes.
অনেক কথাই বলা হয়েছে। Yes, disposed of. ওই দুটো চেঞ্জ করে দেবো। হ্যাঁ। Next.
Item number 19.
My application, same prayer, my lord. It is a bit different, my lord. The employee dies. Wife is, my lord, praying for the year.
I have passed order in case of widow.
Lord, then finally make it not today, my lord. I shall.
Very well, not today. Take it back, your exhibit service. In case of widow, I have passed order. Bring that order. Yes.
Item number 20.
The next matter for similar matters.
Same matter. Widow.
Petitioner.
Lordship, I am for the state.
I am for the state.
Huh? Okay, state.
You are for the state.
Sir, ভুল লিখেছেন।
Executive service you have filed. Assistant teacher.
Assistant teacher.
30th June 2011. Date of retirement.
Yes, ma'am.
PPO 1st December 2015.
Yes, ma'am.
Have you annexed the PPO?
Yes, my lord. L16. One please.
সব পিটিশনার করে করে পড়বে বুঝলে বাহাদুর সিং সব পিটিশনার করে পড়বে এটা না এইভাবে করবে না আগেরটা ফলো করবে এটা ভুল আছে এটা মানে ভুল না মানে এটা আগে আগে দিতাম এটাকে চেঞ্জ করে দিয়েছিল হ্যাঁ এই প্যারাগ্রাফটা দেখবে ওই প্যারাগ্রাফটাই ওই 12 weeks from the date of communication of this order ওই যে প্যারাগ্রাফটা এটা এখানে এরকম ভাবে দেবেন বুঝতে পেরেছেন ইয়েস ডিসপোজ অফ হ্যাঁ An advocate of the petitioner submits that the petition is not pressed.
Item number 70.
70, Lordship, I am appearing on behalf of the school authority. Your
Date, where is she? Yes. Who is he? When he will come? Tomorrow? Well, not to. Tomorrow, generally application date. So you have difficulty to do. So not this week. Not this week.
Not this week.
Not this week.
Monday, that for it.
Item number 71.
Of that. Last of which, Your Lordship directed me to serve the notice upon the learned GP also. That I have, my clerk has gone, but the GP office refused to, unfortunately, to receive the notice. Instructed me to serve upon the learned advocate on panel who is appearing. I have also served them. And I have sent the notice to by email to the learned office of the GP.
Not this one. This one not this one. আগামী 16 তারিখে ভিও 16 তারিখ।
Prior to that, when you have served upon the government, Peter, government refused to receive the notice. I have sent the email also. Refused? Yes, my lord. Unfortunately, my lord, I specifically pointed out my clerk also. I had spoken to them. They told me that you served the notice of the learned advocate who is on panel, who is appearing. I said that his lordship's order is there. That's why your endorsement is there. My clerk, they refused. This is not unfortunate. Who has made this endorsement? Not my clerk, who she went there and tried to serve upon the notice, but they said no, you served upon the she pointed out. And I also, over telephone, I told that kindly receive this, or lordship's order is there. Probably the GP doesn't know those, they always insist for serve notice upon the panel at bed. And your lordship's last order is also there on 7th March. That also I've served the notice. Every service is there. Very unfortunate. Mr. Lahiri, in spite of the direction given upon the learned advocate representing the petitioner to serve notice upon the learned government pleader, office of the learned government pleader has refused to accept the notice. I have never seen this. I never seen this.
That's not happening.
Nowadays it is happening. They are insisting to serve notice of the panel advocate. They were not appearing. That's why I had a talk also over. Yes, yes, definitely. Yes, I sent the notice by email also. I was compelled to send the notice by email. Inform the learned government pleader. Yes, immediately inform the court is calling him. Inform the government pleader immediately. Yes, yes, I will accommodate this. Yes. No, no, you go and inform. I will take up your matter. Next matter is yours. Yes. You are Mr. Sen.
I want to.
Your name?
Okay.
What's up?
I have spoken. I'm also spoken.
Pass over. Pass over.
My lord.
ওর ম্যাটারটা আছে পরে, ওর তারপরে একটা ডাকো, দুটো পাস ওভার করে রাখো তো।
Item number 73.
Plan for the commission.
Just Yes, report. Just a minute. Mr. Rai, what is happening? Twice, wait for some time. Right? Did you filter off? Password. Oh. Twice matter was taken up, nobody represented the state respondents. Court directed for ensuring representation on behalf of the state respondents to serve notice upon you to take steps. And your officers refused to accept the notice. Learned advocate representing the petitioner by filing an affidavit of services stating that the office of the learned government petitioner has refused it.
Generally it doesn't happen because I generally endorse it.
And with the order of this court, this notice was attempted to be served upon your office.
But I tender my
Generally,
doesn't
it is
happen,
known
but-
to us that the system which is followed by the office of the learned government pleader is this, that the concerned advocate should be served.
No,
But
when it's
in
a
the present
direct
case,
order, it comes to me.
I generally do not pass this order. But in the present case, twice the state respondents are not represented and matter is relating to non-payment of pension. So the state has to be heard. Now, since twice the state respondents were not represented, I have no other option but to direct you to direct the state learned advocate representative petitioner to serve upon you. Now the office is refusing it.
That doesn't happen. This is mail becomes very difficult. Mail is something which is এই অফিসারটা বলুন তো কোনজন? But I'll look into it. But
Yes, sort out the issue. I am just adjourning the matter for 7 days. You take steps for engaging an advocate to represent the state
That's what I
respondents.
do because this is something very
Very unfortunate.
I'll take steps with it. I'll definitely take steps.
When the clerk of the appearing advocate is going with an order of the court and notice to effect
That's what I'm
service of
saying,
notice.
like, generally, that was what was being followed. I completely changed it. I take it on my hands, but I am here till 7:30. I do that only. But
So that's why
I must be asleep. I'll take care. I'll
Yes,
also, I'll
please.
also summon the officer, madam.
Yes, please take
Sorry,
steps.
madam, tender my apology, and also to my learned friends,
No,
madam.
that I know that you do not.
No.
Very well, matter is adjourned for the day, not this week. You take steps, Mr. Rai, take steps in the meantime. এই এসো তো একটা order করে নাও তো ওটা। First matter.
But I'm appointing here and now Mr. Lahi.
Very well, very well.
And he's a very, well, he's one of our best.
In most of the matters, when I find that there is no representation, I engage somebody with a direct request to the office of the learned government pleader to regularize such engagement. That is done. But in this case, since repeatedly the respondents are not represented.
It's my office calling, madam, I tender my apology, madam. I appoint Mr. Lahiri, madam, and after that I'm looking into it, madam, why this is happening.
But take steps in the meantime that who has refused it.
Definitely, madam. I'll
Yes.
look into it. Yes, madam.
Notice has been served in terms of the order dated 2nd April 2025 upon the office of the learned, in terms of the order 2nd April 2025. However, state respondents at the beginning is not represented. Subsequently, Mr. Rai, learned government pleader, is present in court, who has in court. Stop. Mr. Rai has submitted that Mr. Subro Prakash Lahiri, learned advocate, will represent the state respondents in the matter. Stop. Hearing of this matter stands adjourned till 22nd April 2025 in order to enable Mr. Lahiri to obtain instructions. Stop. The learned advocate to the petitioner is directed to serve copy of the writ petition upon Mr. Lahiri by tomorrow, by 11th.
At this moment, 6 Old Post Office is under fire. Yes,
When?
it's got major
When it
fire.
broke out?
Just now, madam. Now just the ambulance and the fire.
Fire tenders have come. Must be due to short circuit.
Just in front of
Position of electrical wiring is
very difficult.
such, it's very difficult.
That-
Must be
that-
due to short circuit. Now it is under control.
And I was just looking to now we are.
And a heavy smoke is coming.
Heavy smoke, heavy.
And smell also.
Well, take steps, Mr. Lahiri.
Yes, yes.
Yes, yes, just.
না, আমরা এটা কত ডাকলো 71 হ্যাঁ 73 Yes. ঠিক একটা আছে বোধ হয়।
38 teachers are working against 9,347 students. But DI has said that at present, if 10% rule is 10% rule is applied, in that event you are coming within the zone of consideration. But at the relevant point of time, you are not within the zone of consideration. But in a pupil teacher ratio does not permit this. 38 teachers against 9,347 students. How this transfer is transfer on general ground is can be permitted? Give a copy to him. Very well. Obtain instructions issue. In terms of the order dated 18 March 2025, a report in the form of a report dated 4th April 2025 of the District Inspector of Schools AC Murshidabad is placed before this court and same is taken on record. Just a minute to do this. বসো তো একটু।
কোনটা ধরলো আপনি? এই তোমার ধরেছে?
ইংলিশে ছিল না? হ্যাঁ, এসো এসো।
হ্যাঁ, কত চেঞ্জ?
Is filed today and same is taken on record. Or is কি বলেছি বলো? Same is taken on record. Next part. Learned advocate representing the petitioner has prayed for accommodation to go through the report and if required, he will obtain instructions. Stop. As prayed for on behalf of the petitioner, hearing of this matter stands adjourned. Stop. List the matter under the same heading on 6th May 2025. Obtain instruction. Great. Next. Yes, call item number 48. নাকি একটা হয়ে গেল? হ্যাঁ, একটা পাস ওভার যেটা ছিল সেটা।
Lordship, you report may be kept on record.
Yes, yes.
Grateful, Lordship.
Item number 72.
ও, নিউ মোশন, আমি ভুল দেখছি। Just a minute. 72. Yes, 70. এটা 73 হলো। হ্যাঁ, হ্যাঁ। Yes, yes, 72.
No, it is court engaged for it. Yes, yes, my lord. Last section, Lordship engaged me in this matter. My lord, I have obtained instruction. This is regarding his non-payment of Provident Fund. Now, today we received the instruction. There was some technical problem in the portal.
Well, I'll consider. Oh, in this matter. Just
70. Yes, yes.
Just a minute.
Why is it great case? तो बात तो 74 से है।
Yes, yes.
Yes, my lord, the problem was at the end of the school authorities. There is some technical error, that is online balance capturing in the portal. Now the school authority has assured that the problem has been resolved. With him, other employees also suffered due to this, but now they have taken steps and it will be done immediately. This is the instruction from the school I have received.
83.
You have applied for withdrawal in February 2024.
Prior to that,
No, the school is saying that.
previously before retirement, I have played for.
Now, on February 2024, what happened?
Again, I have played. Well, I'm
So let me
retired.
dispose it of directing them to a school and the state to release your provident fund dues by 7 days.
With interest. Otherwise, I am.
But you will not get interest beyond 6 months.
I have due to their lapses, I have suffering.
My lord, his application in the writ petition is of February 2024.
Yes.
Yes.
So I
but
don't know
that is
how
what-
it can be done previously. That is the usual process of pension, gratuity, and other benefits. But during service, how can someone pray for provident fund?
After retirement, I have played for.
The first application is of 5th February 2024.
February you have prayed and then you
Yes.
filed the writ petition in the month of February.
February.
Yes,
So
that's
what
the-
prevented you from after retirement on 20th February to come within the reasonable time?
I have every time I have approached before the school authority.
That is not
That
the
is-
issue. Issue is you are seeking interest. So therefore your alacrity has to be explained before this court.
Like in 2024, I am entitled.
That is wrong approach, because you should have come because it is to be counted from the date of your retirement, and as per statutory condition provisions
I am entitled
you are
to
in
6
6 months.
Yes, that's true. But
So let me direct the authorities to release your, since you have not received the provident fund, release the same within 7 days from.
Yes, my lord, kindly direct the school authority to complete the procedure, then we will do it.
Yes.
Yes, yes.
Yes,
We will,
Along with statutory interest.
yes, that is
as
my-
admissible in law. As
Along with the interest for a period of no. You have not come within time.
he
That
retired
is
in
the main
20th February 2022.
that normal procedure on the date of return, I entitled to get my
You
retirement
retired on 28th February 2022 and
Yes, my
filed
lord.
writ petition on
That is one
2nd
of the-
July 2024.
My lord,
After 2 years.
my lord, one thing regarding interest, it should be counted the first 6 months after retirement. Now, by going by that, he's not entitled for interest then. But when he files the writ petition, 2024. So 6 months from date of retirement up to 6 months. Now he
So that's
crosses the
payable. That will be paid to the petitioner. Maximum 6 months can be paid.
maximum 6 months, but he comes at 2024, not for that period, so much of the 2 years.
Issue. Matter is heard in presence of the learned advocates representing the petitioner and state respondents. However, in spite of service of notice, authority of Ombikapur Altaf Hossain High School within bracket HS close bracket not 24 Parganas being respondent numbers 5 and 6 are not represented. Stop. Next paragraph. The learned advocate representing the state respondents submits that there was no fault on the part of the state respondents in releasing a provident fund, but in releasing provident fund in favor of the petitioner, but due to laches on the part of the school authority in taking steps within time, provident fund dues could not be paid to the petitioner. Stop. In support of such submission, letter of the headmaster of Ambikapur AH High School within bracket HS South HS the North 24 Parganas dated 10th of April বললাম না আমি বলেছি দেখো তো letter of the ডেটটা বলেছি 10th of April dated 10th April 2025 is placed before this court and same is taken on record. It is also stated in the letter dated 10th April 2025 that petitioner applied for withdrawal of provident fund dues in February 2024. Stop. However, it is admitted. However, it is stated in the said letter that the issue is resolved and the school authority is taking steps for release of provident fund immediately. Stop. Next paragraph. In view of the letter dated 10th April 2025 of the headmaster of the aforesaid school and the submission made on behalf of the state respondents as well as the petitioner, writ petition stands disposed of, directing the authority of Ambikapur AH High School within bracket HS North 24 Parganas being respondent numbers 5 and 6 to 5 and 6 as well as District Inspector of Schools AC North 24 Parganas being respondent number 3 to release provident fund dues in favor of the petitioner with statutory interest for a period of with statutory interest within a period of by 7 days from the date of communication of this order. Stop. Writ petition stands disposed of.
Server copy of the order.
ঠিক আছে। But since there are technical issues, 7 days would be difficult for us, possibly. From the school, we have to obtain it. No, so that it can be complied.
I give 48 hours time.
Yes, I know, because these are the school's part. I will hardly get few minutes, maybe. Kindly give me at least 2 weeks time. I will do it for compliance of that order. That's why I'm submitting, so that can
by 7 days from date.
At least 10 days.
By 7 days from the very well. By 10 days from
10
the
days.
date of communication of
Because
this
it's
order.
School's part.
By 10 days from the date of by 10 days from the date of communication of this order. Stop. Land advocate for the petitioner is granted leave to communicate server copy of this copy of the order duly downloaded from official website.
I'm grateful. I'm grateful, madam. Extremely grateful.
Without waiting for certified, duly downloaded from the official website.
Usually it is not.
Next.
Well, may I just make one request? The last matter, Lordship engaged me. One line may be added with junior of my choice, because since I'm entitled to have, otherwise it gets difficult if it is possible. If it is possible, my lord.
দেখো তো আগে অর্ডারটা কি বলেছে
70
ওই যে যেটা বললাম না লাইডি হ্যাঁ এনগেজমেন্টটা দেখো
otherwise it is
71
যতটা পারবো করে দেবো আমি করে দেবো যখন আমায় বলবেন আমি করে দেবো
না in this matter stop Mr. Lahiri will appear Mr. Lahiri will Mr. Lahiri will represent state respondents along with junior officers.
I'm grateful, man. I'm grateful.
পড়ে তারপরে বাকি
I'm grateful, madam.
Next one.
Otherwise, it is so difficult to obtain instruction now from the various authorities.
Yes,
I'm grateful, madam.
Item number 74. এটা কত suppose হলো 72 23 হয়ে গেছে order passed 74.
And for the state, my lord, lead by
just a minute.
Mr. Abhishek.
Yes, five affidavit.
Exception. My lord, Lordship please to consider their exception, my lord. Kindly, my lord, come to the page 5, my lord. Last occasion, the ambiguity arises regarding the definition of teacher. My lord, kindly come to page 5, my lord, the aim
Of page
of
5.
my lord, page 5 of the exception, my lord. Teachers mean an assistant teacher of school recognized.
Page 5.
Page 5, man, aim.
Yes.
The teacher means an assistant teacher of school recognized as such by the board of council as the case may be, and includes the headmaster and headmistress, as my learned friend pointed out last occasion, my lord. Headmaster, assistant teacher, assistant headmaster, assistant headmistress. For the purpose of these rules, however, the assistant headmaster and assistant headmistress may seek transfer of assistant teacher. My headmaster cannot seek, my lord, transfer of assistant teacher, my lord. That is my instruction. It is a single post.
Is it an application for transfer as assistant teacher?
Yes.
Assistant.
Assistant teacher, yes.
From the post of headmaster?
No.
Assistant.
Assistant teacher to assistant teacher, my lord. Now, my lord, in our report, my lord, we have disclosed the quota has been already fulfilled, my lord, because my lord, the two transfer has already been.
Why you are submitting this? That assistant headmaster and assistant headmistress may seek transfer as assistant teacher.
Now, my lord, my landed friend last occasion saying, my lord,
It is a case of transfer of an assistant teacher from one school to another.
My lord, kindly
So how
consider.
that is relevant?
My lord, kindly consider my report, my lord, what we have stated in our report, my lord.
That including headmaster 21 teachers, excluding headmaster 20 teachers.
20 teachers.
Now, according to the petitioner, that
2.1
headmaster is to be considered as a part of teaching staff.
Yes.
And that the number of teaching staff should be assessed at 21, not 20.
Not 20. Now, my lord, headmaster is a single post, my lord. So, my lord, if you want to try to transfer the headmaster, he has to be appointed as a headmaster only. Now, my lord, the quota has been already fulfilled.
Quota means 10%.
10%.
10%. Question is, if 21 teachers are to be taken into consideration,
yes,
then it should be 2.1.
2.1.
2.1 should be rounded up to the next higher digit. That means 2.1 should be treated as 3. 3. So if 3, then petitioner is coming under the zone of consideration, applying 10% rules.
Yes.
As contemplated under Rule 5.6 of the Transfer Rules of 2015.
Yes.
But if headmaster is excluded from the zone of consideration,
yes,
then the number of teachers will be 20, not 21. If 20, then the two teachers can be permitted to transfer.
Our
That
case
is the case.
Our case
Now,
is headmaster is excluded.
Aim, last sentence of Rule 2M will come in your aid.
Now, my lord, there is single post of headmaster. Now, my lord, that has to be excluded, my lord. Now, if Lordship kindly consider my report, our report says that.
Is there any judgment or order on this? Nothing.
What happened, my lord?
No, but one thing is this.
Yes.
Because assistant teacher post is a single teacher, is not a single teacher post.
No.
Assistant teachers can be transferred from the post of assistant teacher to the another post of assistant teacher.
Yes.
Now, yes, rightly it is pointed out that an assistant headmaster can also seek transfer as assistant teacher.
Assistant.
But headmaster cannot be transferred from the post of headmaster to the post of assistant teacher or assistant headmaster.
Assistant.
So it's a single cadre post.
Single cadre post.
Subject to correction, my lord. My learned print is.
The result would be, if the headmaster is transferred from A school to B school, there will be no headmaster in that school.
Yes.
Yes. My lord, total teacher. My lord, kindly consider total teacher. Headmaster is including the definition of teacher. My lord, transfer rule deals with the teacher. My lord, headmaster, my lord, so far my learned print is
Headmaster maybe as a teacher, headmaster can get transfer. Assistant teacher should be treated as assistant headmaster should be treated as an assistant teacher. But I have held this point. When assistant headmaster transfer in another school, they should be treated as an assistant teacher. They has been minimized. Their scale has been minimized. But all are teachers.
But if your contention is accepted,
yes,
in that event, headmaster can never be transferred. But I have come across the cases where headmasters are being transferred.
Yes, very much.
And that transfer application is being allowed. Be reasonable before this court that your contention is this is a single cadre post.
Yes.
It's a single post.
Yes.
Now, if it is a single post in a school,
yes,
then if your contention is accepted,
yes,
then headmaster cannot be transferred because he is holding a single cadre post. Never transfer application of the headmaster can be entertained. But in the portal, there is no bar. Headmaster's transfer application is entertained.
Understand what is calling for a lordship, my lord. Now, my lord, my instruction is this, my lord, the headmaster must be excluded from this, my lord, this policy. As we got a single post.
Well, no, my lord, it is not correct. Well, entire teachers, well, definition, assistant, when assistant headmaster is transferred in another school, their approval as an assistant teacher. Language is very clear.
Come to 2M again, rule 2M.
Well, may I
read it.
Teacher means an assistant teacher of school recognized as such by the board of council as the case may be and includes the headmaster or headmistress. I'm posing for him, the headmaster, headmistress coming under the
definition of teacher.
Now, my lord, kindly with the rest of
assistant
the
headmaster, assistant headmistress.
Mistress for the purpose of these rules. However, the assistant headmaster or assistant headmistress may seek transfer, my lord, as assistant teacher.
That is an additional leave granted to the assistant headmaster.
Yes.
But in case of a headmaster,
yes,
he has to be transferred from the post of headmaster to another
headmaster.
But while counting the number of teaching strength in a school, why headmaster is to be excluded, taking into consideration the definition which is attributed to the term teacher.
And my lord, rules, rule 5, sub rule 6, 10%, quite 10%.
And it is not a case of transfer of a headmaster. It is a case of transfer of an assistant teacher. Headmaster is not seeking transfer. But while counting the number of teaching strength, whether headmaster is to be included or to be excluded, then one has to fall back on the definition of teacher. The definition of teacher says, teacher means an assistant teacher of a school recognized as such by the board or council as the case may be, and includes headmaster and headmistress. Specifically.
Page 7, kindly see page 7.1 when 10% rule has been.
A teacher, the definition is, it is defined that teacher.
Teacher.
That I have seen.
The school authority of particulars shall not forward application received from more than 10% rounded up to next higher digit of total number of teachers. Of that priority shall be given first to the teacher, senior, that teachers.
সেটাই না
Now 21, if it is counted 21, you are coming within the zone of consideration.
That is my challenge. My DI is refused. That I have not come.
10% not rounded up to next higher digit. Means 2.1. If headmaster is included, 21.
Yes.
Then 2.1 comes to 3.
School is issuing NOC, but DI is restricting that you are not come under the zone of 10% as per total status.
In this case, school has issued an
Yes. Page 7.
Oh.
Page 70. My lord, kindly see. My lord, my application date is 15th of July 2022. Applicant to HY. 26th of August 2022.
Now, if I accept your contention that it's a single cadre post, then the headmaster will never be permitted to take transfer.
why is it happened?
Since it is a single, it is not the situation.
Yes.
Headmasters are also permitted to make application for transfer. This is the first point. Second is school. It is not a case of transfer of the headmaster, transfer of a teacher, and the definition of teacher includes headmaster, headmistress.
The explanation of the DI malad in my report is says that not the
issue.
Also, kindly clarify the same malad, no, otherwise
Yes.
This point
creating
there is-
ambiguity.
This point there is not.
A reply taking an affidavit taking exception to the report filed on behalf of the state respondents, comma, is placed before this court and taken on record. Stop. Next paragraph. Petitioner made application for transfer on 15 July 2022. 15 July?
Yes, yes.
15 July.
2022. On the ground of distance. In between the present school of the petitioner and his place of residence. Stop. Stop. Such application was made on Utsotsi portal and same was forwarded by the authority of Lohai Sammilani Vidyaniketan within bracket HS, Purbo Ward 1. Hereinafter referred to as the said school. On 26th August 2022, to the District Inspector of Schools, AC Purbo Bardhaman being respondent number 4, for taking further steps. Grievance of the petitioner is, in spite of receipt of transfer application by the respondent number 4 on 26th August 2022 through portal, said respondent number 4 has refused to forward the transfer application of the petitioner to the West Bengal Central School Service Commission for taking final decision on the transfer application. The respondent number 4 in his turn has sent back the transfer application to the said school authority, and the said school authority has sent the transfer application back to the petitioner on 9 September 2022. Next paragraph. Learned advocate representing the petitioner submits petitioner has been wrongly excluded from the zone of consideration for transfer on the specious plea that he was not coming within the zone of consideration on applying embargo relating to 10% of teaching strength of the said school as envisaged under Rule 5 within bracket 6 of the West Bengal School Service Commission within bracket general transfer on special grounds and reallocation close bracket rules 2015, hereinafter referred to as the said rules of 2015. It is specifically submitted that while considering the transfer application of the petitioner, respondent number 4 is required to count headmaster of the said school as one of the teachers, and if same would have been done, in that event, total number of teaching staff of the said school would have been counted as 21 instead of 20. Stop. If transfer application of the petitioner was considered based on 21 teaching staff working in the school, in that event, petitioner would have come within the zone of consideration, since as per Rule 5.6, as per Rule 5.6, against 21 teaching staff of the said school, 3 would have been permitted to take transfer, applying rules relating to 10%. Stop. Next paragraph. On the contrary, learned advocate representing the state respondents has opposed this writ petition on the ground that headmaster is a single cadre post in the said school, or headmaster is a single cadre post in the said school. Is a single cadre post in the school. Therefore, headmaster therefore, while calculating number of teaching staff working in a school, headmaster should be excluded. Stop. It is also stop. Reliance is also placed on Rule 2M of the said rules of 2015, wherein definition of teacher, quote unquote teacher, T capital, wherein this definition of teacher is provided. Stop. It is also stop. It is also contended in reference to said Rule 2M that an assistant headmaster / assistant headmistress can be transferred from their respective post to a post of assistant teacher, whereas headmaster cannot be transferred from the post of headmaster to the post of assistant teacher. Therefore, headmaster should be excluded while counting number of assistant teachers working in the school. Stop. Next paragraph. Having considered the respective submissions made on behalf of the parties, issue which needs to be examined is whether on the anvil of said rules of 2015, headmaster is to be excluded while counting total number of teachers working in a particular school, in order to apply Rule 5.6 when more than one teachers are seeking transfer from the said school to another school. Stop. Now, from one school to another school, from one school to another school. Stop. In the present case at my hand, there are 20 assistant teachers and there is headmaster. Now, there are 20 assistant teachers working in the school apart from headmaster. If total teaching strength is considered as 20, then applying Rule 5(6) of said rules of 2015, 2 teachers can be permitted to take transfer. And if headmaster is taken into consideration while counting teaching strength of the said school, in that event, there will be 20, in that event, there are 21 teachers based on which Rule 5(6) is required to be applied. Next paragraph. In order to decide the issue, this court finds it fit to consider definition of teacher, T capital, quote unquote. This court is required to consider definition of teacher attributed in terms of, or definition of teacher ascribed in terms of Rule 2 within bracket M of the said rules of 2015. Stop. For better understanding, Rule 2M is quoted below. Small m. এবারে 2M টা page 5 এদের যে reply এখানে পেয়ে যাবে. Is quoted below. Stop. On plain reading of aforesaid Rule 2M, it appears that the term teacher, it appears that the definition of teacher includes assistant teacher of a school, comma, headmaster, headmistress, and assistant headmaster / assistant headmistress. Stop. Therefore, as per said rules of 2015, there is no bar in counting headmaster in order to find out total number of teachers working in the school. Stop. Next paragraph. Another issue is required to be taken into consideration, that if the submission made on behalf of the state respondents is accepted, that the post held by the headmaster is a single cadre post, or post held by an headmaster is a single cadre post. In that event, headmaster should not be permitted to take transfer from one school to another. Stop. However, that is not the present situation in terms of. However, there is no bar in transferring the headmaster of one school to another school in terms of the relevant provisions of said rules of 2015. Stop. Headmasters are regularly being permitted to take transfer in accordance with the relevant statutory provisions. Next paragraph. In view of aforesaid discussion, and taking note of the definition ascribed in terms of Rule 2M of the said rules of 2015, respondent number 4 ought to have counted headmaster of the said school in coming to a conclusion as to how many teachers are working in the school. It is indisputable that including headmaster, there are 21 teachers working in the school. Stop. In terms of Rule 5(6) of the said rules of 2015, if in a school 21 teachers are working, 10% constitute 2.1, which needs to be rounded up to next digit, that is 3. In the event 3 teachers are permitted to take transfer, petitioner is coming within the zone of consideration. Stop. It is also indisputed, or it is also a fact. It is also a fact that the said school authority has allowed the transfer application of the petitioner and forwarded the same through portal to the respondent number 4 for taking further steps to process the transfer application. Stop. Next paragraph. Hence, respondent number 4 is directed to forward the transfer application of the petitioner to the West Bengal Central School Service, to the Chairman, West Bengal Central School Service Commission by 7 days from the date of communication of this order. And on receipt of same, the chairman, the respondent number 3 shall decide the transfer application of the petitioner in accordance with law by 4 weeks thereafter. So the decision to be taken by the respondent number 3 shall be communicated to the petitioner by 10 days thereafter. Next paragraph. It is made clear that transfer application of the petitioner shall not be rejected on the ground of suspension of portal. Next paragraph. Writ petition stands disposed of, urgent xerox service.
I'm grateful.
All the fixed matter.
3 p.m. matter, item number 83.
Yes.
My lord, this is the,
Have you disclosed the period?
yes, not the period. My lord, basis of calculation is the age.
Where, which paragraph?
Yes, my lord, paragraph 5 onwards. How the calculation used to be made and
কন্টেন্ট আছে ওর কন্টেন্ট আছে ওগুলো পড়তে মানকে পুরো একদম ফাইল একদম তো বসানো আছে কন্টেন্ট where is the period you have stated?
Lord, it is not
Then
calculated.
how you have calculated?
My lord, that is why, that is how the
Lump
explanation.
sum amount has to be
Yes, how
determined.
the lump sum.
Suppose commutation is 100 rupees at the rate of 1/3 or 40%. In that event, 100 rupees into 12 into for a particular years,
No,
15 years. Otherwise,
Particular-
how you have
yes, that
you
is
have
that,
derived
that,
the calculation?
just
I had,
my lord,
I had talked with the statisticians who had prepared informally, of course. I can't put it officially. Please take note page 5. And page 4 together.
yes, four is the lordship kindly have a look
That's what your lordship wanted to know.
the basis.
Please come to page
how,
4.
how the amount is
I
determined.
showed your lordship, they should have been here before the court at least. Commuted value of pension.
Where?
At
Page 4,
calculation.
paragraph.
Page 4.
Paragraph 8.
Therefore, the formula for calculating.
Yes.
For calculating the commuted value of pension followed in KMDA was or is as under. Commuted value of pension is equal to commuted portion of pension. So that's 40% or
1/3. Previously,
whatever.
now subsequently 40% into commuted factor as shown in the table.
Commutation factor as shown in the table. But I shall come to this later on. Why
Into
multiply
12
by
months.
12 months?
Yes.
This is actually years. Why? Please come to the next page.
Unfortunate.
Unfortunate and misleading, I should say. Please come to the next page. Paragraph Roman 3.
Yes, in the case.
Superannuation pension is 8,000. That's in
Just a
respect
minute,
of one of the
just a
employees,
minute.
petition number 30.
Pension is 4,405, 4,405, commutation pension, 50%, 1762. Commuted portion of pension is 40%, age of 61 years. Commuted factor as per table 9.81. Commuted value of pension, 1,612. Yes, it should be 12 years.
It is
Otherwise, if you use a calculator, let us see.
It is 12 month and for example, Milo, three petitions.
Just a minute, just a minute.
Are taken.
Just a minute. Now, if it is multiplied with 12, multiplied by 12, then it is coming to 2,07,420.
Okay. Figure is all right.
It is, are you submitting that it is for a year?
Please come to that.
No,
Roman paragraph
this
three.
is month. This is how
for
the
1 year.
calculation.
It is for 1 year.
1
No,
year.
I should try to explain. But please come to that Roman paragraph 3 at page 5.
In case of petition number 30,
By way of an example for a single petitioner.
From three wing, three persons are
40% for age of his age on.
this is the amount which was deducted, which was commuted rather.
9.48. Yes, same, but commuted factor gets changed.
No, I shall show you why. Commuted value of pension is 3,340 multiplied by the factor.
Commutation factor as per table is 9.48, but previously it was 9.81.
That will differ from person to person. If the age is more, the factor will be less. Now, because the time period to refund the amount is short, therefore the factor gets less. Now, please come to that last entry column E under paragraph 3. Commuted value of pension is 3340
into factor.
The factor multiplied by 12 is equal to 3,79,000 and odd. So every month the
every year.
Every month the commuted portion is 3340. The second entry B. So if you divide 3,79,000 by 3340, it comes to 113.76 months, which is equivalent to 9.48 years.
This is
And
done
no,
not only.
My learned friend will allow me to complete this. So by 9.48 years, this 3,79,000 rupees had been refunded as principal amount. 12 years is reckoned by reckoning the interest factor, interest amount. So 12 years. But why are they allowing restoration after 15 years? Suppose somebody does not live for 12 years to refund the entire amount. So the person who is not refunding the actual amount, his burden is being shared by such person who is surviving for more than 12 years. So for 15 years, he is paying not only his own debt with interest, but also the debt which somebody else might not have paid.
So actually it is less than 10 years.
Less than 10 years.
Then in 12 years.
With interest.
With interest. Then thereafter it is extended to 15 years.
Because
if other employees, retired employees die before in that event, their burden is to be shared by the
That's
other
how the statisticians calculated this. Now please come to page 9 of this affidavit.
But they will not come up with clean hands that it is for a period of 15 years.
They will never say so.
No, my lord.
Despite the court wanting an assistance in this regard.
No.
Please come to page 9.
This is not deliberately, my lord.
Please come to page
I
9.
humbly submit, my lord.
Please come to page 9.
This is how the calculation is made.
Had they stopped at 12, I had nothing to say. Why did they indicate 12 months?
This is the formula used to be
Please
applied.
Come to page 9. Commutation value for pension.
Page 9
of that affidavit, same affidavit.
That table refers to factor.
Commutation value for a pension of rupee 1 per annum.
So if I take commute rupee 1, what would be the amount for that entire year? Please see that the first column is age on the next birthday. So one can start commuting from the age of 17. Commutation value expressed as number of years of purchase. Please see the expression. I am purchasing this.
Commutation
But the
this number of years.
greater is the number of years, the factor is reducing.
Age on next birthday.
The value of rupee is reducing.
Where you are getting the value of rupees 1, it is against rupees 1 per annum.
Yes, it is 19.28 for a person who commutes at the age of 17 years. The first entry. Please come to the third column.
Age on next birthday.
Yes.
Age on
But
next birthday.
for a person who is commuting at the age of 62, the factor is 9.48. The value of a rupee is 9.48. The third and fourth columns. I apply at the age of 61 years for commutation, it will be
9.48.
Yes. That's why please now come back to page 5. That's why that factor 9.48 is mentioned, and this has to be reckoned with years.
So if anybody applies at the age of 62 years,
61.
Very well, at the age of 61 years,
be given
in
to me
terms
at
of Annexure 2,
Yes.
in terms of Annexure 2,
It will be
in
given
that
to him.
event against commutation value for a pension of rupees 1 is 9.81.
That's the factor. And that is
If at the age of 17 years, it should be 19.28.
So the lesser is the age, he gets a greater number of time to refund. Therefore, it's more at a young age.
So therefore, the period is imbibed or is included in this factor.
Yeah, and that is yearly basis. That is why
They are
per
getting the
year.
advantage of not disclosing the year.
Value of a rupee per year.
Because if anybody considers this table at page 9, then this period is included there, implied there.
Now please come to page 10. This was after ROPA 2009.
Yes, Justin. Page 10.
Page 10.
Yes.
Revised commutation value for a pension of rupee 1 per annum. This was after ROPA 2009. Now please come to 61, that third table, third column rather.
No, 60, yes, 61.
The factor has changed to 8.194. What was 9.48 earlier?
Earlier 61, it was 9.81.
Yes, 9.81.
Now it is 9.194. It gets reduced.
And
so this factor is related to the period.
Value of a rupee per year on commutation. That is the commuted value of 1 rupee in 1 year. Now, please see, one can commute up to the age of 81 at page 10.
Yes. Yes.
And see how the figure has drastically reduced because he has lesser chance. And now see the just after the table, that endorsement after the table, that writing. Basis is LIC 94-96. LIC had calculated this figure in 94-96, which forms the basis. Ultimate tables and 8% interest.
This is not applicable to this.
So this 8% interest calculated on the commuted value takes us to 12 years with the additional figure, and I am shouldering an additional liability
of my of co-pensioners.
In view of a contingency where a pensioner might not have survived up to 75 years.
So taking all these factors together, it comes to 15 years.
And there is no question of referring any months into reading months into 12. because the factor is on yearly basis.
But the
Actually, by 9.48 years, I refund the actual principal amount of commuted value. By 12 years, I refund this with 8% interest. Another 3 years, I absorb the liability for some persons who might not have refund them.
But this period of 15 years is always constant.
Is constant for central government, wherever commutation is
This
allowed.
for 15 years.
That's the statisticians calculated, not the. It was done by LIC in 94-96. By 94-96, 81. The table was since 1981.
if your lordship kindly considers page 7 of my report.
That's why they get an escape route not to disclose 15 years or 10 years.
No,
On the strength of this table.
Had they mentioned 12, I would not have used those harsh words. Why did they mention months?
No, this is how the calculation is made. We are bound to disclose it.
Where the months they have stated,
Just come to page
4.
4.
This is how the calculation is done in respect of all the, not only the writ petitioners, other employees also.
Therefore, the formula for calculating the commuted value of pension followed in KMDA was or is as under. Commuted value of pension is commuted portion of pension multiplied by commutation factor as shown in the table multiplied by 12 months.
Yes.
But why 12 months you have stated?
My lord, this
Factor
is
on yearly basis.
my lord, if it is multiplied by 12 months, the factor is multiplied, then this amount comes. I have given the calculation in
For 12
respect of
years.
12 months, my lord. It is calculated, then the amount will be fabulous amount. This is how the calculation used to be made, and in respect of the petitioner.
Come
also,
to page 9 again.
yes.
Come to page 9 again.
Yes, yes.
Heading Annexure 2,
My lord.
Wide Regulation 38.
Yes, yes.
Then commutation value for a period of ₹1 per annum.
Per annum.
Is not per month. What is the meaning of per annum?
Annually.
Then-
Yearly.
Based on this unit of ₹1 per annum, this table is formulated.
But this is calculating.
If it is 17 years, then commutation value expressed as number of years purchase. Number of years purchase.
Yes.
Number of years purchase. 19.28. If it is at the age of 61, it should be 9.8. So it is relatable to year, not month. So why you have stated month?
This is how the calculation is.
No, it is completely wrong considering the Annexure 2 and the inputs of Annexure 2.
And in case of the petitioners, 3 examples I have given, 1, 2, and 3.
Mr.
In-
Talukdar,
in
tell your clients not to be so cunning before this court.
No, my lord. This is
Or your clients are
my
trying
lord,
to
I have
outwit this.
I have on several occasions talked to them, my lord. This is how the
No,
calculation.
on what basis this months is stated?
This is the formula, my lord. They
Have you followed Annexure 2 or not?
Yes.
If Annexure 2 is followed, then commutation value for pension of ₹1 per annum. Where from you are importing month? I want to know from you.
My lord, 12 months. What has been explained to me, my lord?
If you have
Here-
a case straightway,
Yes.
make out this case. But
My lord,
don't try to
my lord, nothing-
outwit this
my lord,
case
my lord,
in order to frustrate the claim of the petitioners
no,
who are
no.
pensioners.
We are not trying to, my lord. My lord knows it is about, in the writ petition also, the principle we agreed.
Very well. These considerations I don't think
12
you
months
will
here.
understand. But you have to explain that why you have affirmed an affidavit where in page 4,
Yes.
paragraph 7, you
Yes.
have stated that commuted portion of pension into commuted factor as shown in the table, this table into 12 months. Why?
My lord, these 12 months.
On what basis you are getting this 12 months?
12 months, it is, if your lordship sees, my lord has seen, commutation value for a pension of ₹1 per annum. 12 months, it was calculated as 1 year.
Will you change your affidavit, or I will direct your officer to remain present to explain it
No,
and to
this
face
is-
the music?
No, this is the formula, my lord, how the calculation is made.
You are playing with the fate of this the pensioners by
we are-
making wrong statement. Where from you are importing month? You are not up till now you have not been able to explain it. Nowhere it is stated in the table at page 9 of your affidavit. Commutation value of pension of ₹1 per month, per annum. Then again in the second column heading, commutation value expressed as number of years purchase. Years purchase, not months purchase. So it must be based on a factor or commuted value which is relatable to a year.
My lord, to my understanding, my lord, that here 12 months.
No, your understanding will not do. What the annexure 2 says has to be clarified. What you understand, I may understand many things.
Is 12 months.
I may believe that the sun rises elsewhere.
Well, this table, what my learned.
Where from you are
That's
getting
a-
this? That this 12 months?
This table, this factor itself indicates the years. That's true.
So where from, Mr. Talukdar, you are importing these 12 months? These 12, this months, 12 months, right? Commuted portion of pension, that is either 1/3, subsequently 40%. Then the commuted factor, as indicated in annexure second column of annexure 2, and then into 12 months. Why? What is the basis?
It's yearly. If 12 months indicates year.
Because if you disclose it for a period of 12 years or 15 years, then everything will be clear.
No,
before
if you
this
lordship,
court.
for a moment, lordship, if you
You
lordship,
have to come clear.
No, lordship,
Everything cannot be fastened on the shoulder of the state. You have to come clear that because you have made the payment and the payment is based on annexure 2.
Yes.
Now your original affidavit in opposition was vague so far this aspect is concerned. Therefore, court has granted you leave to file a further affidavit explaining the position that what is the time period for which this commutation is.
My lord, if you lordship kindly consider page 7, the application for commutation. I have stated in paragraph.
Yes.
5.
Page 7, Form H.
Yes. Paragraph 6 I have stated. Lordship will
Page
not
7,
find
Form H, it's a pro forma.
pro forma.
Yes.
In the form, lordship will
in pro
find,
forma clause 7. Or
no,
which
page
clause?
7. Page 7,
Page
there
7,
is no,
annexure A.
yes, annexure A, there is no, my lord, point as regards the period for which the employee concerned.
That is in your rule, that period is silent.
Silent.
Silent. Question is, you have made a payment.
That
in spite of, you could have said, you could have made asked for a clarification from the state authorities. So if this is silent, on what basis this calculation is to be made? You haven't done this. You have calculated it. If you have calculated it, simple question I have put to the concerned authorities of KMDA that for what period this calculation was made.
Well, this is
clause 5 of that page 7. Entry 5, serial number 5 of page 7.
what is the date and year of your birth. That is
page 7. Then do you suffer from any complaint? Clause 5.
Likely to shorten your life.
If so, that's different.
That's how the factors were calculated.
This is the
Where you are importing this month and you have made a statement on oath.
This 12 months, my lord.
You have made a statement on oath. Yes. On what basis this month was incorporated?
This is
instead of year. From where you are getting? because these are the relevant documents you have annexed. Page 9 is completely silent so far it is, so far your calculation is concerned based on month.
Table shows rupees 1 per annum.
Per annum.
Per annum. So
Not only this, second column, commutation value expressed as number of years purchase. Everything is on the unit of year, not month.
My lord, this calculation, my lord, what I my lord, could gather from them, this 12 months is taken, my lord.
So
since
why
it
you are
is
not
per annum.
disclosing this?
Per annum.
Why you are not disclosing this?
My lord, this is the
in spite of repeated direction of this court.
My lord, this is
that it is for 12 years or 15 years for
no,
10
not
years.
not years.
Now
This
it
is why-
appears from the submission of Mr. Mojumdar it has to be for 15 years as per norms.
My lord, if the table is interpreting the table, Mr. Mojumdar is making submission.
And on what interpretation you are saying that this is for this is on monthly basis?
Not monthly basis.
Very well. Mr. Mojumdar's interpretation is wrong. If I proceed on this premise, then tell me or satisfy the query of the court that on what basis you are saying today that it is on a monthly basis, which led the deponent to make a statement
This formula itself shows, my lord, this was calculated yearly basis. But the period for which
where is there is no whisper about month. Your annexure 2 is clear on this. There is no ambiguity.
My lord, this ratio is shown.
Commutation value of pension of commutation value for a pension of rupees 1 per annum.
Per annum.
Commutation value for a pension of rupees 1 per annum. If pension is rupees 1 per year, in that event, what would be the commutation value? That will be the determinant factor for calculation. It is on yearly basis.
Yearly basis.
So why you have stated on oath that 12 months?
12 months means 1 year. That is.
I would not permit to keep this affidavit with this wrong inputs.
This is yearly basis. 1 year equal to 12.
Otherwise,
months.
you have to file an appropriate affidavit by 7 days. I will not permit this. Because matter will travel, I know, on this. Therefore, there should be no error in my record.
Well, instead of 12 months, if we read, my lord, 1 year, that will come as yearly basis.
Yes. So say so by filing an affidavit.
And since no period is mentioned in the
file a clarificatory affidavit, admitting that this is a wrong statement and the yearly it is on yearly basis, this calculation is made. Matter ends. Matter ends, Mr. Talukdar. Otherwise, you have to demonstrate before this court that what you have said is rightly said in terms of Annexure 2.
May I come back, my lord, in the next week?
How long this see that the
My
age
lord,
of the petition?
I thought, my lord, that this formula itself will.
You are working in this field, practicing in this field for pretty long years,
Yes.
and you are. I have given you enough time.
My
This
lord,
was,
that-
this
my
order
lord,
was passed on 18
yes.
March 2025.
Yes.
Otherwise, I will direct, as I have indicated, that your chief executive officer came this and should remain present before this court on the next day to
Okay,
clarify
give
the
me-
situation.
Give me 1 week time next week. Let me.
Yes.
In the next week.
What will happen in the next? What will you do?
To clarify this formula, I will take instruction. my lord, on this.
I deter that in the next week you may come that it is on a daily basis.
My lord, this is the formula what on the basis of which the calculation is made. That is why they are stating on affidavit. My lord wants clarification on this formula. My lord, I shall obtain instruction on that.
Come clear. They are your employees. They have put in their
my lord, as I understood-
entire tenure right up to 60 years.
My lord, as I understood, my lord,
Irrespective of the fate of this writ petition, what is fact? Disclose this before this court.
yes, My lord, that has
Don't
been.
take a tacit stand before this court.
My lord, that has been disclosed, my lord. My lord, I
How
also
this is wrong disclosure.
I
It
also
has been
understood.
clarified by your learned friend representing the petitioner appropriately.
And
now I am ready to accept your contention if you clarify this.
This is my lord.
Government may say many things. Government may come with a different case, but what you have done by calculating the commutation of pension, that should be actually placed before this court.
My lord, in case of the petitioners,
Then
I have given
Mr.
this
Talukdar,
example.
if this is for a period of 12 months, then what you have stated in your affidavit in opposition? Let us clarify. How do you reconcile this?
In affidavit in opposition?
Yes, yes. Let us come to the affidavit in opposition.
This part, this was not. Paragraph 7, Lordship will find.
Just a minute.
At the middle, Lordship will find.
Understood.
Paragraph 7. That part I have not.
Three and 4.
No.
Respondent number?
Respondent number 3 and 4. Yes, yes. Paragraph 7
Let's
only.
come to paragraph 7.
Yes, yes.
Read it.
My lord, as per regulation 38 of the Kolkata Metropolitan Development Authority Employees Death Cum Retirement Benefits Regulation 1988 and the provisions contained in para 10b v of the order of revision of pension, family pension, pre 1996, post 1196, between memo number so and so issued by the so and so, a retired employee may commute a pension portion of his or her pension up to 40% at the time of his retirement. There is no specific provision in the said regulation 1988 for determining the period of commutation as mentioned above. Therefore,
Then
the
how
amount
you have said
commuted
it is on monthly basis?
month here month.
Yes, yes.
Well, a month means
How
one,
on a
one
monthly
year,
basis?
12 months. The table says the rupees 1 per annum. So it was considered.
How you have said in this affidavit in page 4 into 12 months? If there is no period?
12 months is taken, my lord, considering this.
Therefore, you have deviated from your own stand. As it appears, what is the statement in paragraph 7? That retired employee may commute a portion of his her pension up to 40% at the time of his retirement. There is no specific provision in 88 for determining the period of commutation of commutation as mentioned above. Therefore, the amount commuted by a retired employee at the time of his or her retirement is being deducted from his or her monthly superannuation returning pension till his or her death.
My lord wanted that clarification.
Till his or her death. Now you are saying that it is 12 months.
12 months for determining the commuted value. Commuted
Yes,
value.
a limit of everything. Now you are saying it to 12 months. Previously in your affidavit you have said that there was no time limit. It is it is signed by, that is up to the date of death. Now 12 months, and this 12 months has no basis.
No, in this affidavit also we have stated paragraph 6, paragraph 5, lordship.
No, where from you are imported the first of all your stand which is being expressed with regard to the period for commutation is not in sync with the stand as it emanates from paragraph 7 of your affidavit in opposition.
Now,
therefore, you have already admitted that it is not for a period of a
particular
till
years.
date. It is not for perpetuity. It is for a period of 12 months. That now this affidavit is also found to be inappropriate affidavit in view of this annexure 2.
But the calculation.
So therefore, tell me that what steps this court should take against your client.
Well, this 12 months, my lord, is taken into consideration, considering page 9, the table annexure 2, that yearly, that 1 rupee per annum. This table shows, then it was multiplied.
First, one after another.
Yes.
How do you reconcile the stand which is taken in paragraph 7 in your affidavit in opposition and paragraph 7 of your present affidavit?
Well, in the earlier affidavit, there is.
So therefore, the wrong statements are made in paragraph 7 of your original affidavit in opposition or first affidavit in opposition.
Milord, here, may I submit in subject to correction, Milord?
You have made a mess of it.
No, for which period the amount was calculated or commuted?
What you have stated in paragraph 7, there is no time limit. It is till the death of the employee. Now you are saying for a period of 12 months. That has no basis considering annexure 2.
That annexure 2 says, Milord, yearly basis. 1 year.
So we have said, why you have said on monthly basis?
No, months to 1 year equal to.
No. So what is right?
No, 12 months is 1 year, yearly basis 12 months. That is 12 is taken, mentioned there. 12 months, that is 1 year. How the amount was determined, and in respect of the petition,
annexure 2 is very specific. As Mr. Mujumdar has also rightly pointed out, that commutation value of a pension of rupees 1 per annum, commutation value for a pension of rupees 1 per annum. If a person earns rupees or commute rupees 1 of his pension for a year, then what would be the determining factor?
If I correctly understood, Milord, what is his submission? This
is not on monthly basis, Mr. Talukdar. This is on the basis. It is on the basis of rupees 1, which is the rupees 1 of the pension of a pensioner for a year. What would be the commutation value expressed as number of years purchase?
Yes, it would be about 10 years. According
now,
to
if age of a retired employee is 61, then against rupees 1, it should be 9.82. If age is 17, against rupees 1, it should be 19.2.
So in effect,
so everything is based on pension of rupees 1 for a year.
For a year.
If
here
reckoned as months, then what I am commuting every month. I get 3 lakhs rupees every month.
12 months. This is year.
So why you are not disclosing it appropriately?
Well, this is being followed. This is being followed and just a minute.
Restored after 15 years. He doesn't have the responsibility.
No, just a minute. In respect of the petitioners, I have
also had the
no
other person who is a retired person wouldn't have
First of all, a stand which is taken in paragraph 7, it is contrary. Then a stand is taken which is found to be faulty. Now today, I have no option. I have to direct your executive officer to appropriate officer to appear before me to explain.
No, here Lordship will consider this, applying this formula in respect of these petitioners. The amount.
Chief executive officer came there to appear. Let him appear and explain.
This will not.
What
allow me.
I have shown enough kindness.
Allow me to clarify that. What my lord wants, that why 12 months? Give me, my lord has given enough.
12 months. It is 12. It is yearly basis. It is apparent from this annexure 2.
So,
why 12 months? Further explanation I don't require. At the cost of pendency of this writ petition for indefinite period. Petitioners are dying.
And in respect of these petitioners also, I have given this example. The authority has not deducted more than that amount what has been.
Don't have any that kind any minimum sympathy towards your employees who have worked for the entire period up to 60 years.
My lord, we have every sympathy.
It doesn't appear so from your affidavit.
No, that is why, my lord, we the authority recommended, wanted to add. First of all, we wanted to add one regulation.
You are trying to mislead this court. In spite of giving an opportunity, I passed order on 18 March 2025, and this affidavit has been affirmed. Enough time was granted. Matter is fixed today, 10th of April, and you are filing this affidavit, which has no basis, saying that on a monthly basis for a period of 12 months this has been done.
This is 12 months.
There will be a wrong in my record that I will not permit.
12 months.
It has to be clarified appropriately. If it is 12 months, you have demonstrated before this court on what basis this 12 months you have written.
Just give me a last chance. Give me a last chance.
Situation.
Yes, my lord, I followed. I understood, my lord. Here, my lord, what I understood, my lord, that 12 months will indicate, it indicates the yearly basis. Since the period is not there, so it was before 87, it was not in the state government also. The commutation used to be made in that way, applying some or other formula. There was no specific period. The
Mr.
period
Mudumdar, that is the crux of the issue.
But the state
If
government.
it is determined, everything will be
But
clear.
it will appear from that table itself. Please come to page 5 once.
Yes,
once
yes.
more.
By page 5 of today's affidavit.
Of today's affidavit. But any other explanation will be absurd.
Yes, page 5.
That clause E, that paragraph, that entry against E.
Page 5E under Roman 2.
Under Roman 3. Under Roman 3.
Roman 3E. Yes, commuted value.
Commuted value of pension. This value of pension is one lifetime commuted value. I don't get commuted every month. Total figure is 3,79,958. That's multiplied by 3340.
That is 40% of the pension.
40%.
So that's the commuted value of pension multiplied by the factor multiplied by 12, 3,79,000. So not every month I'm receiving less. The less figure is 8350 minus. So 3340 is the less amount. Is the lessened amount. So if we divide 3,79,000 with 3340, the figure comes to 113.76 months. That is 9.48 years.
Similarly, if this 2,07,422 is divided by 1762,
it will come to 9.48.
This table itself will indicate the years.
So by 9.48 years, I am refunding the principal amount.
My lord, this may be, my lord, this
Then interest up to 12 years,
8%,
and thereafter
the prospective
sharing
loss.
the burden of other pensioners. If they
contingent loss.
Yes, contingent loss.
That loss, my
So
lord,
taking all these factors together, the period is determined 15 years. You did not enter into these calculations. You should have simply said that this is for a period of 15 years.
15 years.
No, there is no provision in the rules.
My lord, since there is the period is not mentioned.
For the court, Mr. Talukdar.
My lord, this is what, my lord, nothing we have suppressed. We are not trying to twisting anything.
No. It doesn't appear so innocent. So far, this
15 years, 15 years, the state government,
he is
the
trying
state
to
government
outwit
employees.
the court as well as the other side by taking advantage of this complicated formula in order to arrive at a conclusion that what would be the commutation value for in respect of 15 years in connection with one retired employee.
Well, 15 years taking into 15 years or for 10 years, that was not
Everything is on
calculated.
yearly basis. Because yes, it is rightly pointed out. Come to page 5 of your affidavit. Total amount, if case of Mr. Bimalangshu Kumar Basu Mollik is taken into consideration, total commuted value of pension is 3,79,958. Then the per month deduction is 3,340. Now if you divide at 379,958 by 3,340, find out.
That he has calculated.
113.76.
That rate comes. That 9.48 comes.
So this is
My lord,
precisely
since-
for a period of 12
My lord,
years, in and around 12 years.
My
10
lord,
to 12
we are unable to say
considering
this.
the age of the
My lord,
employee, retired employee.
My lord, we are unable to say
Because this factor gets changed with the years, with the age.
But since there, my lord,
Start
since
from page
Yes.
17 years and it comes up to 85 years. So therefore, this factor, this commutation value expressed as number of years purchased, it gets changed.
it gets changed. So the
But
formula-
everything is based on yearly basis.
on
year.
yearly basis.
So why you have stated 12 months?
12 months means year indicating that year that is shown. And since there is no specification of the period, that is why we wanted, my lord, because 87 order was not made applicable to the KMD employees. We wanted to amend the regulation. That was regretted. Like some other
What is
cases.
the position of your regulations? That is accepted. You cannot improve it, you cannot change it very well. But what you have done in calculating the commutation of pension, that should be disclosed by filing an appropriate properly.
My lord, only if your lordship appreciates this 12 months considers as 1 year, then there would be no, my lord, in my respectful submission, there will be no further requirement.
Multiplied by 1.
No, then
If it is year, then it is 1.
one year means 12 months.
12 months is equal to 1 year. Then if 1 year is substituted by 12,
then
the
amount-
entire
and
amount will be changed.
calculation will be changed.
It is for 12 years,
No.
not 12 months equal to 1 year.
No, my lord, that I have inquired from them, my lord, this is not years. That is why they have stated on oath, paragraph 6.
Show me any provision based on which you are taking it as months. Show me, yes. You have to show it now by 5 to 10 minutes. Otherwise, I will direct your executive appropriate officer to appear before me. Because again, he will play with the court by saying that it is not 12 months, but it is 1 year. Then another affidavit. By this way, this 6 months will be pass in the meantime.
Without wasting your lordship's time, my lord, may I come back on some other day, my lord?
On what for what?
Just to explain this, where from this 12 months?
No further explanation. I am hearing you for more than half an hour on this issue.
Yes.
No. Either you have to file an affidavit disclosing that the actual period that is on yearly basis. Otherwise, I will direct your officer to come and explain. Choice is yours, Mr. Talukdar.
না, এটাই তো বলছি। ওটাই তো বলছি। Let me come with further explanation. Give me a chance.
But don't play with the court.
Till date, my lord, we are
appears
not
so.
playing.
It's
We
very
are not
unfortunate, but I am compelled to express this, that it appears so.
My lord, kindly do not take in that way, my lord. We have not suppressed anything.
Very unfortunate. It's a statutory authority.
Yes. 12 months, my lord, that what I understood, my lord, I shall get it clarified and file a clarification.
It's not a cheat fund organization.
That's true.
It's a statutory authority.
And
he will not come clear before this court while filing an affidavit, irrespective of the fate of the writ petition.
My lord, this
Where from your client has learned this?
This is how the calculation
You are before the
was-
High Court. Court has given and directed you to file an affidavit indicating the points which are required to be clarified, and you have filed an affidavit which has no basis at all.
Well, this is the formula you applied in case
You
of
have to assist the court, Mr. Talukdar. You are representing the statutory authority without considering the fate of the writ petition. At the end of the day, the retired employees of your organization are before this court.
Well, this is how the calculation was made in respect of the petition.
That you see can you comprehend the outcome? First, you file an affidavit in opposition. That opposition, the stand taken in paragraph 7 in affidavit in opposition is found to be not a correct stand. That is corroborated by this affidavit, which you have filed today. Now you are saying I require further clarification.
No, regarding this 12 months, Lordship.
Why this mistake will happen in your affidavit?
And considering this, taking this 12 months calculation was made in respect of while.
No, answer is no.
This is the calculation.
Answer, you are making a wrong, you have made a wrong statement.
No, this petitioner is not denying that this amount they have commuted. And this was the basis of calculation of their commutation. And from records, these figures are put, my lord, here from records.
So if you stick to this affidavit, I have no hesitation. How to deal with this issue, I know very well.
My lord,
I have no hesitation in dealing with this matter. If you say that no, whatever I've done rightly, then yeah, very well. Very well. Let me pass an appropriate order. Or if you pray for time to clarify that no, it is on yearly basis, then I can grant you 10 days time, not beyond that. But if you say that no, it is rightly done, then if it's right done, I will direct.
Let me file a clarificatory affidavit, my lord. But one submission, my lord, I make, my lord, based on this formula, this calculation was made in respect of the petition as figures are shown in the affidavit. They are not disputing this figure. And this 12 months was applied in case of these petitioners also. This is how the calculation was made and the amount was commuted in respect of these petitioners. That is why, my lord, I understood, my lord,
if
that
you find that no, this is the correct stand taken by the KMDA, then submit it before this court instead of making an attempt to clarify it. Submit it. This is the stand.
Let me come with it. Or else, my lord, lordship, kindly give me some time to take instruction.
No further instruction. By filing an affidavit, you have to clarify it. I am hearing you for 1 hour. Mr. Mojumdar has submitted for 10 minutes, then I am hearing you. You have failed to clarify this. So therefore, further clarification is not required so far this court is concerned. Either you have to file an affidavit clarifying this, otherwise I have to direct your officer to appear before me and clarify that where from he is importing this 12 months period.
Let me come with an affidavit.
Yes. In terms of the previous order, dated 18 March 2025, Chief Executive Officer, Kolkata Metropolitan Development Authority has affirmed an affidavit on 26 March 2025 and same is filed. Stop. Next paragraph. On perusal of the said affidavit, court finds that an effort has been made on behalf of KMDA to explain that the calculation was made for determining lump sum amount towards commutation of pension of the petitioners based on the period of 12 months, as it emanates from paragraph 7 within bracket Roman 2 of the said affidavit. Stop. A calculation is also given in paragraph 8, capital Roman 2 and capital Roman 3 of the said affidavit. Stop. However, the stand which is taken today by filing an affidavit that calculation was based on a calculation was made for determining commutation of pension is based on the on the period of 12 months is found to be inappropriate in view of a document at page 9 of the said affidavit being annexure Roman capital 2. Stop. On perusal of annexure Roman capital 2, it appears that calculation is required to be made based on commutation value for a pension of rupees 1 per annum. Stop. Next paragraph. On posing query in reference to the particulars provided in annexure 2, comma, to the learned advocate for KMDA, it is submitted that a clarificatory affidavit is required to be filed on behalf of KMDA in order to disclose whether calculation was made for determining commutation value of pension on yearly basis or on monthly basis. Next paragraph. As a last chance, 10 days time is accorded or afforded to Chief Executive Officer, Kolkata Metropolitan Development Authority, to file further affidavit disclosing the correct period for which disclosing the correct period taking into consideration of which commutation value of pension was determined. So far petitioners are concerned. Stop. Let this affidavit be filed by 10 days from date. List the matter under the same heading as 3 p.m. matter on. First May 2024.
My lord, this affidavit filed by the incumbent, he has been transferred. Someone has joined.
Yes, I have directed
the
Chief Executive Officer, Kolkata Metropolitan.
So another person, he has been transferred 2 days back.
Mr. Majumdar, please come back. Rule is silent, but calculation cannot be silent with regard to period.
Only the amount we have deducted that we have disclosed. Only
For what you are not trying, you are trying not to disclose it, that can be apprehended, comprehended. That can be comprehended. That can be.
Let me try once again to sit with
Unless
them.
one himself suffers, he will not know.
Yes. They are your employees, Mr. Talukdar. They have put in full period of service up to the age of 60 years.
My lord, we have every sympathy. That is why
I am not saying that you give. Court will decide it, but assist the court appropriately. You are a statutory organization, not a cheat fund cheat fund company. Irrespective of the fate of this writ petition, your duty is to assist the court when court is passing an order directing it to file an affidavit. Why you will not disclose the actual position?
From the records,
it is crystal clear from Annexure 2 that it is on yearly basis, this calculation.
But the record shows that the calculation as was
That
made.
factor under column 2 is relatable to year, not month.
It would be known to the petitioners also that calculation in their respect, my lord, was calculated, my lord, based on this formula.
Very good.
Which we have.
So they are sticking to this. Let us proceed on the.
No,
basis.
my lord has my
Lord has
Again repeating same thing.
Let me get clarification.
Appropriate clarification this court requests. Not for wasting court's time. দেখো
আমারই পাঁচ মিনিট